Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota, and I apologize profusely for being late. If I look basically homeless, it's not because I am the new CEO of Twitter. It's because I have had a really long day with really little sleep, caught in snippets, and while I will blame my initial tardiness on being asleep for just a couple more precious minutes, I will say that Streamlabs took me like 4 minutes to load up. Like when I first typed OMG late, it was exactly 11, and I had clicked on Streamlabs to open, and it took until now. So good job. Good job, me. But anyway, that's where we are. And my hair is just lovely. Ugh. Everything's a disaster. I did a 10-second combing the hair job. But we are here. So we have 3 topics to get to tonight. One of them is a little lighthearted. That is Melinda Scott versus the Chief Janny. The Chief Janny of the universe. The internet police. That is Joshua Connor Moon. Melinda versus Josh is an ongoing saga of love, denial, and betrayal. And we have been following it, so we will continue now with some recent filings from Josh in this lover's quarrel. The next thing we will be talking about is updating the Parler versus Amazon Web Services case. The update you've probably seen. The update you've probably seen is that the judge has denied the temporary injunction request for Parler. So Amazon will not be required to put Parler back on its servers, even temporarily. I think this is a very poor decision by the judge. That's my opinion. Even though I'm not entirely surprised by it. I just don't think it's the right play. I don't think it's the right move. And, you know, you guys can determine what you think is right about it when we read through the opinion. That shan't take too terribly long unless I get distracted ranting about it. And then, F for monetization on this stream. F for monetization on this stream when I talk about the third subject. It's gone, and there's nothing I can do about it, and it's not my fault. It's not because I have a lawyer on here spewing gamer words. It's not because I'm going to issue hate speech. It's because Twitter, the third lawsuit, is Twitter being sued by a minor child for Twitter's refusal to take down child pornography. You heard that. Twitter will take down political wrongthink, no problem, but Twitter and Jack Dorsey love child pornography. This is a problem I talked about when Parler was first removed. I don't know if you remember, but I mentioned it in passing there because I have had people send me or tag me in links where it links to a tweet where they're advertising the distribution of child pornography on Twitter. And Twitter will leave those links up for hours, days, weeks. The response Twitter gave in this one was apparently that it just didn't violate their terms of use. Because Twitter and Jack Dorsey love the abuse of children and they love child pornography. They thrive on child pornography. It drives traffic on Twitter. They leave it up. But yet, my hate speech. My hate speech. Okay. Remember, Section 230 requires a good faith effort to remove this content specifically, but doesn't require it. It protects you given a good faith effort to remove this content. This one they had to sue. Had to sue them. Oh my God. Gets reported. Yeah, this is child porn. You really need to take this down. Nah, we're okay with that. Good job. Good job, Jack. Great company you got there. Good job, Judge. We'll get there. Tomorrow is a new guest, new to this channel. Tomorrow is Nate the lawyer. Nate is an attorney, a lawyer, whatever. He has a different sort of background than some other lawyers from what I've heard. And I would love to hear his story a little bit. He guests on with Uncivil Law several times, and I think we'll have a good discussion. He's been commenting on many of these cases. He has a YouTube channel, so I will be having him on tomorrow. I am in talks with Dan Fraga. To hopefully come on the show soon. I would love to have Dan on again. It's been a while. When we do that show, it's going to be probably more escapism type content and just very chilled and relaxed. I'm trying not to only do, the news, political commentary content because, for the live streams especially, because I know that stuff gets really depressing and you have to balance out what's going on with the world with how you get to step back from it from time to time. So hopefully we'll get Fraga on soon. If you've never seen him, he's a great guy, and I like talking with him very, very much. That get Nate drunk and ask him about G-Man. Okay, I'll do it. We'll work on that. Yeah, I think tomorrow will be a nice drunken lawyer stream. So, the other stuff that's going on, I'll be talking about in various places soon. This idea. Hopefully, I'm gonna invite Barnes on again, and I'm gonna try and set up a daytime show with Viva. I don't know if the Barnes show will be at night or daytime. It depends on what's in his schedule. I'd love to talk to both of those guys because we seem to be, the three of us in particular, seem to be firing on similar cylinders on some of the moves that's going on with Parler, some of the stuff that's been going on with censorship and with speech. The government is apparently removing Trump videos from the YouTube White House channel, and they have a duty to preserve them for records, but they don't necessarily have a duty to preserve them in the same way that they're there. It's not about whether or not they can take the videos down from YouTube. It's about, why? Why are they doing this? What they should do. And my theory has to do with erasing Donald Trump from existence. It's a 4-year amnesia series from a soap opera. That's what we're in. We just woke up. The guy with the eye patch is sitting there next to us. His name is Scorpio or something. And he's like, "What do you remember of the last 4 years?" Anyway, I don't remember anything. Who was the president? I don't know. Every time I try to think of their face, it gets fuzzy. Good. That's what's going on right now. And you can see it. You can see it in Biden. It's Dan Crenshaw. You can see that, and in what's happening with Joe Biden's initial executive orders, which are basically literally undo Trump as fast as possible. Undo it. Get us back into war. Get money back to Warren Buffett. Get this done. Get this done. Reinstate our state cartels. Put them in as fast as possible. Things were changing and we don't want change. That's what's happening. So, I'm hoping to get Viva and Barnes on either the same show or separate shows. I like doing one-to-one shows usually, unless it's specifically a panel type show. But yeah. So there's that. I desperately owe a chat with Kurt on civil law, either on this channel or his channel, and he contacted me a while back, and this week has been turned into a mess, and I have not gotten back to him appropriately. Uncivil, if you happen to see this, buddy, I gotta get back to you. We gotta hang out. It's been too long. So that will be that's a priority for me. Getting Kendra Paris on the show to talk about gun stuff. I believe Florida has some gun legislation that was sent to me by Blaine. And I need to look at that. And that would be a great show to rope Kendra Paris back in. She is a red flag attorney down in Florida. Great guest that I haven't had on in far too long. So those are all things that are in the works specifically right now with guests. There's more guests, of course. But yeah, trying to balance out content like tonight, where it's going to be me going through documents, trying to balance content with guests. That's all, that's in the works. Okay. And briefly, if you're here and you are a person who is interested in the quo warranto, the writ of quo warranto idea, because you saw it on a website, I'll probably have to address this in a video, and it's probably going to make people a little bit upset. But let me just suggest that no judge was willing to enter into the election for any reason at all. They weren't willing to step in. It's highly unlikely that a DC circuit judge is going to issue a writ to remove the President of the United States from office. I don't know who's been telling you this. I don't know why this has become like a popular idea. A writ of quo warranto, as far as I know, has never even been considered against a president, and it may not be something that can be done legitimately against a president of the United States, because it would, in fact, infringe on Congress's impeachment power, and it would give that power to a DC circuit judge. So while the text of the language may suggest that any officer of the United States could be removed, officer, either military or civic officer, which would in theory include the president, the idea that that would be a constitutional removal of a president when the power of impeachment is solely in the hands of the legislature, I don't see it happening. And I will humbly suggest that if you're looking for a magic word solution to Joe Biden being president, there isn't one. At this point, it's basically done. If something big were to come out and he would be impeached, that's a possibility. He would be removed. They'd have to impeach Kamala Harris as well, which would typically need to involve her being implicated in it, and it would have to be big enough to cross the aisles dramatically. Vote. In 4 years, vote. For the next 4 years. Reinforce your personal life. reinforce your loved ones, improve yourself, build your networks. That's what you do. That's what you do. So, that's the option. So, anyway, I'll probably have to do a video on it. I've gotten several requests from people who view the show nightly to people who are new to watching the daytime stuff. And I do apologize. I didn't get any daytime stuff out today, but I seriously spent every free moment I had of the day sleeping, and I still only ended up with 5.5 hours, I think, of sleep, maybe 6 hours of sleep between my Twitch stream ending yesterday and now. So the Act of 1871 explanation, please. I don't know what act that is off the top of my head. I'd have to look into it and do research. Okay, let's jump into this now that I've spent the first 20 minutes rambling on. People have basically arrived, and we are going to look at this. We got the Dragon's we got a couple chats, and we're going to pull up Melinda Scott's documents, burn through those, and then hit the Parlor one, and then we'll get into the Twitter one and see how far we get. Okay, Dragon's Treasure says, people, buy my tea. I give Nick more money. See how that works? Buy more tea, give Nick more money. Otherwise, the terrorists win. Who the terrorists are is up to you. Just buy more tea, damn it. That is the dragonstreasure.com. It is high quality tea, high quality loose leaf teas, also with anime, Japanese animation themes. Check them out, thedragonstreasure.com. If you love high quality tea, go there. It's really great stuff. And if I was drinking it now, I'd probably be more awake. Kiwi Goes Live says, this is in addition to last night's donation. Hey, thank you. Ty's reaction was amazing. The spit take he almost did when you mentioned wanting to discuss part of my chat was mwah, comedy gold. Also, Trump can still win. Google Trump's Rule 34 to learn more. No, don't you dare do that, Kiwi. Stop it. Why? Why are you like this? Why are you like this? Sixth Floor Madness says, why do women not like wearing skirts in the winter? Chapped lips. Oh my goodness. And then there's I think an imposter donation. I think there's an imposter donation from Bob Ricada who says, are you winning, son? I don't think that's actually him. He usually donates on YouTube, not on Streamlabs. But I'll pretend it's him because he probably would ask that right now. Biden the Cold One says, hey, Nick, my power is back on for the moment. A transformer exploded last night at 10 p.m. and it came back today at 6 p.m. Dang. Apparently there was a fire underground. It shot a manhole cover up into the air. I hated that I missed Ty. Aw, man. That sucks. But welcome back. Glad your power is restored. Bad Vibes says, Twitter, where maps and cheese pizza are acceptable, but making fun of a 2-ton symphony singer and having an opinion isn't. Welcome to 2021. Yes, that's it. Bad Vibe says, okay, Nick, nap time's over. You got 1 minute. That was right before the show. And then he says, next time law twits start insulting you, just ask them, do you service the judge with those lips? I saw you ask that to the one guy, and man, that got me blocked. I didn't even do anything. To that guy. Sunny Day says, hey, lawman, it's my first super chat ever. Hey, thank you. Welcome. Just wanted to say that I really enjoy your content. Keep up the good work. Love from California. Hey, back at you, Sunny Day. Thanks for being here and hanging out. I appreciate it. Legendary Devil Hunter Dante says, Nick, get the flamer. The heavy flamer. And Bad Vibes also says, oh, Nick, you sweet, hopeful boomer. There's a magic word solution to Biden, just it isn't uttered in public. Stop. But yes, this was actually, I think I want to cover that thing real quick at the beginning of this. Let me pull up Melinda. Melinda's documents. I had them, sorry, but sleep. Okay, so we've got one document from Melinda and one document from Jersh, the Chief Janny, the sweeper of the internet. Oh, whoop. Here we go. Let me get this set up here. I love scanned documents. Bam! Okay. Let me also do, Socialism is for Fig, says Nick. Go to the speech that got unlisted by White House at 1 hour, 16 minutes, 37 seconds. You can hear Hunter say he accepted a plea deal. What? All right. Oh, real quick. I do want to do this thing real quick with, Barnes. Hold on, I'm finding this tweet real quick. This was such an interesting response, and it triggered people, and I just want to, like, I don't like indulging too much on this type of stuff, but I want to point out something. I'm gonna wait a minute. We're gonna read through this, and then oh shoot, I won't have the retweet handy, but it's okay. I'll explain. So Robert Barnes says, FYI, this is likely unconstitutional at Joe Biden. And says, White House has disabled the comment section of the government YouTube channel. Okay, so that's Barnes's assessment. The White House has disabled the comment section of the government YouTube channel. Barnes says this is likely unconstitutional. Okay. Very simple. Very simple. Then I say, right now, I'm not confident that even the same circuit court would rule this is a First Amendment violation. And I said, then I offered my opinion. It should be. I think it should be. I think that there's a comment section. The White House is using YouTube as an official platform. Same with Twitter. And I think that people should be allowed to respond. That's my opinion. Notice my case assessment. I'm not confident that even the same circuit court would rule this is a First Amendment violation. And that is a reference back to when they found Trump's personal Twitter account to be a public forum that the government was not allowed to block people from. They weren't allowed to block people. Now, there are arguments that can be made that they are different. And notice, I said right now, I'm not confident. And yet, I have weirdos out there like Jay Woolman, who's like, you're wrong. Like, what do you mean I'm like, what part of it is wrong? If my opinion on how it should be is wrong, that's an opinion on how I think it should be. But are you saying my assessment is wrong? Because I think my assessment is right. And let's be clear. He's saying that I'm wrong, but he's not taking the side of Robert Barnes here. He's taking the opposite side. But notice the interesting thing about, and I don't have the tweet handy, and I don't really feel like perusing through Jay Woolman's tweets. But the interesting thing is, of course, that he's not confronting Barnes on this. He's confronting me. And the reason that this probably even came to anyone's attention, notice this is a nested reply on Barnes. So it's not like my followers immediately saw it or anything. You kind of have to stumble across it. Um, the interesting thing, of course, is some law Twitter idiot found it. And he's like, you know, what are you talking about? You don't know what you're talking about. And then I pointed to the case where it was a First Amendment violation for Donald Trump to remove people. And then I mentioned that, you know, the people said that it was likely a First Amendment violation for the Twitch military or the U.S. Army Twitch channel to ban people from asking about war crimes and stuff like that. So, which I did a couple videos on. And these people, it's like they forget immediately that this stuff happened. And then they think, well, it can't apply the same way. But they don't have a legal reason as to why it can't apply the same way. Their conclusion is derived from Joe Biden can't do it wrong, Trump did it wrong. And then they go backwards through the process to get there. But again, I don't think a circuit court would find the same violation. I don't think it would be the correct decision that they did it, but I don't think they would end up finding that way. And it was amazing to be told I was wrong by lawyers because I agree with their position. Like, I think that's the outcome. I just think that it maybe should be. I think the courts are behind on technology, and that's, you know, we're going to see more of that in the Parler lawsuit. It's just ridiculous. These people, they're so mad at me still so mad at me that they will go through and find my stuff, even though I'm not like talking to them or anything, just giving my one humble lawyer's opinion. And I'm not alone in that opinion, clearly. Barnes thinks that it should be unconstitutional, or that it is likely unconstitutional. I don't know what he thinks it should be, but it's not like a way out there thing. It's not like this is off in left field. Oh my God. The dishonesty of lawyers on the internet is almost as embarrassing as the dishonesty of lawyers in a courtroom. You DM me on Twitter with a White House video and timestamp? Okay, let's do this Melinda document first, and then we'll get to that. Don't let me forget. Socialism is for figs. If I'm forgetting, you alone have temporary permission after the Melinda and Josh documents to spam me with tags if I forget to do that. Okay? There you go. You have my permission. All right. This is the plaintiff's reply to defendant's motion to show cause. So, Joshua Moon has a show cause motion out there as to why he should have to comply with discovery without being served and all this stuff. And so this is Melinda's response. This is only a couple pages. We're going to burn through this real quick, and then his reply to this response. Now, the first thing out the gate is this should be a plaintiff's response to defendant's motion to show cause. But that's the type of stuff where they do tend to give some leeway to pro se litigants. If you don't know, Melinda Scott is a pro se litigant. She is not represented by counsel here. If you're new to this entire storyline, the very brief backstory is Joshua Moon runs a website. It is called Kiwi Farms. If you've never been there, I would probably not recommend going there unless you want to go into the dungeon of the internet. But Kiwi Farms exists for a very specific reason, and that is to make fun of people that they determine to be lolcows, that they find funny on the internet due to their antics. Yes, you can find a thread on there about me. Actually, there are two. You can find that thread go from lots of praise and lots of chuckles to lately people being pretty upset about the content that I'm posting or whatever. And that's fine. That is where people get to express their opinions, whether we agree or disagree with them. It's okay. They go. At some point, I'm sure the Kiwi Farms will be even less happy with me. And that's, again, that's okay. But I shouldn't refer to them as a monolith because they're not. It's people on the Kiwi farms. And there's a whole bunch of them with varied interests. And there is crossover on the subjects. But generally speaking, people go and they become interested in particular people and they can go read about them. And people are allowed pretty unbridled freedom to say whatever they want. And that's how the internet should be. That is how it deserves to exist. That is what we're asking for on places like Twitter, Minds, Parlor, everywhere. That's what we're wanting from the internet, is for people to have the freedom to be Kiwi farms. But that being said, Melinda Scott is a person who does not like that. She does not like that freedom at all. And in fact, she is very mad about what has been said about her on Kiwi Farms for years, and she is suing Joshua Moon, even though he's not the one saying it, because he hosts the website. She is suing him, and this is, I believe, the 5th time. Yeah, oh, by the way, guys, final thing. You can go to paypig.org and get federated, which is, it's like Twitter, but it's freedom. Paypig.org is a place to go. I can be found on the Fediverse. My new handle is actually at Ricada Law, at verified.af. There are 2 Ricada Laws. The paypig.org one is also mine, but I'm transitioning away from it. If you are from the Fediverse, follow me, Ricada Law at verified.af. That's the, that is the people on verified.af are personally verified. You get an account. I believe it's only people with a specific minimum number of followers on whatever platform they're on. So, you can check me out there if you want. And as Twitter will be ramping down, because it will become hostile to ideas, my posting on Minds and the Fediverse will be increasing. And yes, I will be redoing overlays at some point in the near future to reflect those sorts of connections. But redoing overlays takes time for my art guy. So, all right, that's the backstory. Melinda doesn't like the thing said on Joshua's website, so she's suing Josh. The problem is she never actually served him, but she got a default judgment by pretending to serve him. So, motion to show cause is improper. Defendant Moon has filed a motion to show cause in reference to plaintiff's complaint. The motion for show cause is improperly filed before this court. Let me just spoiler that for you. No, it isn't. Because the plaintiff has not violated any court order for which she would need to explain herself, there is no legal basis for asking for a plaintiff to explain the merits of their complaint using a motion to show cause. A complaint that makes allegations in good faith need not explain itself until the time for presenting exhibits in a hearing or trial, and even then, only after the opportunity for discovery. This is not necessarily true. The actual complaint must, on its face, not only make allegations in good faith, but it must support those allegations. It must support those allegations with sufficiently alleged facts that would lead a reasonable reader to find in favor of the plaintiff, assuming everything the plaintiff says is true. This is a prima facie case, and conclusory statements are disallowed. These are the Iqbal Twombly line of cases in regards to civil procedure. It is not only a first-year civil procedure question, it is like a first-week civil procedure question. It's one of the first things you learn in law school. The court ordered that the plaintiff would be given an opportunity to present her evidence in a hearing. The hearing is the proper place to present exhibits. Nope. This is, the court ordered the plaintiff to request a hearing for the default judgment, which she didn't do. And the exhibits are related to the damages, not to the merits of the case. The default is separate from this. Again, Melinda is arguing from a completely inferior position as she simply doesn't understand what's going on. This is why people recommend you get a lawyer to deal with court. The procedure is brutal. And if you get the procedure wrong, you can lose just on procedural grounds. Melinda doesn't have a case, but her case is further eroded and complicated by the fact that she doesn't understand or follow the basic procedure. All right. Defendant Moon, by counsel, is attempting to proceed by color of law, demanding things from the plaintiff that have no legal basis. That sentence isn't even real. Notice she doesn't have a single citation in her response that the motion to show cause is improper. That's because there isn't one that would support her argument. Melinda has actually included quite a few citations in her documents. She is not incapable of doing it. I'm guessing she was unable to find one that would support her argument in any sort of way. She left it out. So all of this is made up. It's just from her sort of mind about how things work. It is not supported by case law or by secondary materials like treatises on how you should approach a motion to show cause or anything like that. Defendant's counsel lacks standing. Further, the defendant's counsel is not a judge of the court. Defendant seeks to demand information that the plaintiff would otherwise present before a judge at a hearing. Defendant Moon's counsel lacks standing to demand this information from the plaintiff in the manner that he has. That's not a standing argument. I know she may have heard about standing in the news, but that is not how standing works. Motion to show cause, an improper request. Defendant's motion to show cause is a disguised request for production of documents. No, it isn't. It's not at all a request for documents. There's a standing entry of default before this court. Plaintiff is not required to produce documents, enter interrogatories, or request for admissions from the defendant. That's completely untrue, by the way. If there is a motion for default, or if there is an order of default, and there's an evidentiary hearing about the default, the defendant who participates and has an order against them very much can engage in discovery about the damages that are being proposed against the defendant. Of course, Melinda wants to ignore this because she wants to pretend that Josh doesn't ever get to participate in the case since there's a default. But that's not how that works. The court cannot ignore a defendant entirely if the defendant still has some sort of ability to challenge what's going on. So it's likely that Joshua Moon could actually request these things. Now, he hasn't done it. Hasn't done it at all. In fact, he's just had an order to show cause, or a motion for an order to show cause as to why this case needs to proceed prior to the ruling on the outstanding motions to dismiss and the motions for the vacation of the default judgment. This court particularly stated that the defendant, Joshua Moon, is not entitled to present any defense in the case, nor is he entitled to any further notice. Well, there you go. However, I bet he would get to participate in a hearing. Entrapment. Ironically, what? Defendant Moon has refused to engage in discovery up until this point, yet Defendant Moon now states in this present motion that the plaintiff should produce evidence. Defendant Moon, by counsel, undermines his own argument by quoting the fact that Rule 11 states that the plaintiff first must be given a reasonable opportunity for further investigation or discovery. That's not what they mean in Rule 11. Defendant Moon, by counsel, is trying to go around the rules under color of law to demand from the plaintiff exhibits and documents whilst refusing to participate in discovery first. I don't know why she calls this entrapment. That is nothing of the sort. Entrapment is the idea that a government agent induces you into a criminal act that you wouldn't have otherwise committed and then tries to charge you with the criminal act. None of that is happening here at all. And first of all, Melinda has gotten to request discovery, but Rule 11 does not say that the plaintiff gets to ask for discovery and only when the plaintiff receives discovery that the defendant gets to ask. Again, just plainly incorrect readings of rules. Pro se form signed with certification. A pro se litigant signs a complaint with the following understanding. Certify to the best of my knowledge, information, and belief that this complaint is not being presented for an improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. All three of these are untrue. Is supported by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law. All of those are untrue. And the factual contentions have evidentiary support, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Also untrue. And for the complaint otherwise complies with the requirements of Rule 11, which it does not. If the plaintiff signed the pro se form, all elements of this certification were already attested to upon her signing the form. No, those are legal conclusions, Melinda, and they've poked several holes in this argument. Defendant's redundant claims about the merit of plaintiff's filings. The plaintiff has given ample case law to support her legal arguments in each of her responses, replies, and motions. Defendant Moon's continued assertions that the plaintiff's case is frivolous or without merit is false. Okay. This is, so far, the best written paragraph of the entire document. It doesn't mean much, but it is simply responding to the allegation. This is false. There you go. Good job, Melinda. Ricky Bobby, this is not costing her anything pro se, other than filing fees, which are being paid by the taxpayer because she qualifies for informa pauperis proceedings, which means she doesn't have to pay anything. The taxpayer pays for all of it. Issue of service. Plaintiff has adequately stated multiple times in her responses, replies, and motions why she served Defendant Moon at his business address, but none of those are correct. Additionally, Defendant Moon's transient nature, as well as his mother's involvement in KiwiFarms.net, makes serving him at this Florida residence problematic. No, if he lives in Florida, that's literally the rule. You said he lives in Florida, not that he's transient. It would be unlikely that his mother would hand over the summons and complaint to Defendant Moon. That's not the rule. The rule doesn't contemplate the likeliness. Melinda, if Josh Moon, if his residence is at that Florida house, then you can hand it to any competent adult at that residence. That's the rule. I believe that's the rule in just about every state in the union. If that's their residence and a competent adult answers the door and you hand it to him, then you say, you are served. And they are. You didn't do that. If you did that and she didn't hand it to him, you would have a case because you would have followed the rule. If, of course, he lived in Florida, which he doesn't, and that would still be his argument. However, you served him at a business address. So even if he did live in Florida with his mother, your service was improper. You can't now say that he lives there, but he's transient, so he doesn't, so she wouldn't give it to him. That's not the rule. It would be, due to a conflict of interest on her part. No, that's not a conflict of interest. In order to meet the time deadlines required by the rules, the plaintiff elected to serve Defendant Moon at his publicly published business address. That's not the rule. You could have asked for an extension. Why did it take you 90 days to do this? In doing so, plaintiff met the time deadline imposed by the rules for serving the summons and complaint. Nope. This prevented having to refile the case and use up more of everybody's time. No, now you're stuck filing endless frivolous motions about why Josh Moon was properly served when this entire time you could have just asked the court for alternative service. You are literally wasting everybody's time. When he first said, I wasn't served, and that's a default, and I don't qualify for default, she could have said, oh, well, actually, if you weren't served because you don't live there or whatever, then all right, I'm requesting permission from the court for alternative service. He's clearly engaged in this hearing, and then she could make an argument as to why, because he lives in Liechtenstein or wherever it is, Ukraine or Lithuania. I don't even know where Josh is anymore. But she could at least make the argument that because he's there and filing this type of service would cost an extensive amount to the state and he's already participating in the case, then maybe she could serve him by counsel or electronically serve him through the e-service system that's built into Pacer or literally anything. But she didn't do that. Defendant's motion to show cause, a challenge on this court's competency and authority. Melinda, who specifically says that this judge is incompetent and has no authority, is now claiming that Josh is doing that by saying, hey, she didn't actually serve me, though. Defendant by counsel seeks to question the competency of this court's ability to read and assess her complaint. The judges of this court have already reviewed the plaintiff's complaint and deemed an entry of default was justified after a review of the record. The procedural record, sweetie. Wherefore, this court should deny defendant's motion to show cause and allocate these matters to a hearing where the plaintiff can present her evidence as originally ordered. Yeah. Melinda, you have not dealt with the facts of this case. The fact of this case is that you have to address his motion to vacate the default judgment, which you are not entitled to that default. Bad Vibe says, Nick, at what point does a judge call for an in-person hearing to get past motion filings and responses like in this case? Once there has been a motion, a response, and a reply to the motion. Or the time has run out. No, there's one more Melinda and Josh document, and then we will look at the White House thing. So, do not spam me yet. I haven't forgotten yet. All right, here's the next document. This is from Josh. So this will actually be written by a competent attorney, and we'll take a look at the difference here in what's going on. Does document 54 mean this is the 54th document in this case? 54th docket entry in this one. Yeah. So this document is the 55th docket entry. Not all of them are necessarily documents. You can have minute orders and stuff like that that don't have a physical document. Although, I think in this case, there are 55 full documents, though. Okay, so this minute order actually does... Item 34, for example, is a minute order that doesn't have a document attached to it. But yes, generally speaking, that's what it means. Okay. Is that many normal? Oh, that's barely getting started. Many cases go well into the hundreds in federal court. Okay, so we have the reply memorandum of law in further support of the motion for order to show cause. Intro. This court is by now largely familiar with the voluminous history of the plaintiff's litigation against Mr. Moon, at least in part due to Ms. Scott's own chronicle of her litigation filed at docket numbers 29 and 47. Ms. Scott has now sued Mr. Moon at least 5 times in 3 courts, despite her own admission that she'd never even heard of him prior to 2017. Further, she has admitted in various of her own filings and in correspondence to undersigned counsel that all of her suits could have been avoided if only Mr. Moon had consented to remove any discussion of her from a website he maintains. Footnote 1. Ms. Scott repeatedly claims that any non-consensual discussion about her on a website is the tort of appropriation. Mr. Moon, of course, disagrees and points out that in a state court suit for the purported cause of action, Ms. Scott did not prevail. Nevertheless, Ms. Scott has attempted to recycle essentially the same allegations into subsequent complaints and to claim that new causes of action based on the same conduct are not barred by res judicata, claim preclusion, or collateral estoppel. Res judicata, claim preclusion, or collateral estoppel are all of the basic same idea that this has already been dealt with by the court in different ways. In this claim, ostensibly for the intentional infliction of emotional distress, Ms. Scott obtained her first ever legal victory against Mr. Moon. Her victory came, however, not after a trial on the merits, but as a result of obtaining an order entering default against the defendant. Ms. Scott has fought vociferously ever since to maintain that entry of default. She has done so despite facially defective service and process in this matter, and now fights even harder to hide the supposed evidence of her good faith filing in filing this litigation. The plaintiff's efforts to maintain default have not only proven too much about her motives in filing this case, but have also forced her to admit in two of her newest filings that she knowingly served Mr. Moon at an address other than his place of abode. Footnote 2. To be clear, Mr. Moon asserts that he is a resident of the European Union and does not reside in Pensacola, Florida. However, the plaintiff claims repeatedly in this matter and previously asserted in at least 2 other federal cases against Mr. Moon that Mr. Moon resides in Pensacola. Taking the plaintiff at her word that she believes Mr. Moon is a resident of Pensacola, however, her decision to suddenly change tack and serve him in Fort Walton Beach is inscrutable at best and suspicious at worst. I'll mildly disagree there with Josh's attorney. It's not suspicious. She's just an idiot. And that she intentionally hid the existence of this suit even from the family members with whom she claims Mr. Moon resides. And then footnote 3, Lolcows LLC, a now defunct Florida LLC, has a registered agent on file with the Florida Secretary of State. Rather than serve the registered agent for acts allegedly committed by the LLC, however, Ms. Scott has also elected to serve an electronic mailbox, and then alleged that unnamed employees at a mailing center are either employees or registered agents of Mr. Moon personally. Ms. Scott also makes the outlandish accusation that Mr. Moon's failure to renew a business registration for an LLC demonstrates that he is being evasive in this manner, even though Mr. Moon and not the LLC is named as a defendant. She just doesn't understand. That's the whole thing. She's literally has no idea what she's doing. By the way, to keep Angry Baneling sane, if you guys like these streams, please hit like. It really helps. It helps the show. It helps the analytics. It makes YouTube think I'm not hated. So go ahead and hit that like button if you like these streams. Please do. If you don't, I'm not going to twist your arm. Okay. It appears increasingly likely, based on the plaintiff's own filings in this matter, that this case began not only with defective service, but with service so suspicious that it raises grave concerns whether the plaintiff may have attempted to perpetrate a fraud upon either this court or an unserved party. Ooh, spicy. Ooh, spicy. Having purported to serve Mr. Moon at a Florida quick pack and ship location rather than at Mr. Moon's place of abode or at the residence that Miss Scott claims Mr. Moon votes from, Miss Scott swore out an affidavit that Mr. Moon was properly served and obtained entry of default. Miss Scott now attempts to use that entry of default as a shield behind which to hide the lack of evidence or even plausibility for her factual claims against Mr. Moon, and to avoid the requirement of proving rather than merely asserting her good faith in bringing this litigation. This court cannot permit her to succeed in that endeavor. Okay, so the basic gist is her case is invalid, it has no merit, and now they're saying her actions kind of make us think that she knows her case is invalid and has no merit. She's clinging to a default judgment when the proper posture should be that she should, support her default judgment, but she should also understand the very real possibility that she may have to actually argue the merits now that the defendant has showed up in a reasonable amount of time and at no prejudice or cost to her. Siren Jag says, as Kermit the Frog, hey, Judge, whose eggs do I have to fertilize to have this sloot declared a vexatious sloot? Come on now. Miss Scott has sued. Okay, we're on the facts now. Miss Scott has sued Mr. Moon at least 5 times. A brief history is set forth below because the facts of Miss Scott's previous claims illustrates the basis for Mr. Moon's concerns about her good faith in this claim, both with respect to its merits and with respect to Miss Scott's decision to serve an electronic mailbox and obtain entry of default based on such service. First, the plaintiff filed a claim for $15,000 in the Wise County General District Court for appropriation. That claim was filed on 4/6/2017 and dismissed on 6/22/2017. It is unknown how Miss Scott claimed to serve Mr. Moon, but he did not appear at trial and nevertheless prevailed. The publicly available docket in the Wise County General District Court lists a Pensacola address for Mr. Moon. Second, the plaintiff appealed her claim to the Wise County Circuit Court. That case, Scott versus Moon, appears to have been filed in the Circuit Court on 11/2/2017, despite the passage of over 4 months since the judgment was entered in the General District Court. Nevertheless, the publicly available online docket from the Wise County Circuit Court reflects that trial was held on 11/30, and a written final judgment was again entered for the defendant on December 14th. So she went to trial on that one and lost, with Josh not even there. Woo! Third, the plaintiff sued Mr. Moon in this court on November 14th, 2018. The plaintiff filed a complaint in this court captioned Scott versus Carlson et al. This time, Ms. Scott elected to sue for 6 figures rather than merely 5. Through the magic of transferring her claims to federal court, Ms. Scott suddenly reappraised her claims and decided her damages had increased substantially. Although she had previously litigated a case based on substantially similar or even identical conduct in the state court with a demand for $15,000, those claims reappeared in federal court with a demand for $240,000. The docket reflects that Ms. Scott's claim in Scott versus Carlson was based upon alleged diversity jurisdiction and that it was dismissed on December 12th, 2018. Although Ms. Scott never served the defendants in that matter because her complaint was dismissed by the court before service could be undertaken, she again listed an address in Pensacola, Florida for Mr. Moon. In that case, she alleged that Mr. Moon had violated her Fourth Amendment rights, defamed her, and insulted her intelligence. He called her a dummy, apparently. Oh my gosh. We have a footnote. In this section, docket numbers will cite to the docket of the case being discussed rather than to the docket in this case. Even more telling, the plaintiff's claim for relief included a demand to have material mentioning her removed from the internet, and she also sought monetary damages from Mr. Moon and for others for alleged emotional distress. This court's opinion dismissing Scott versus Carlson notes that it was her 8th pro se case in the past 2 years. Some people are addicted to lawsuits. Some people are addicted to lawsuits. The court expressly questioned whether it had personal jurisdiction over Mr. Moon and the other out-of-state defendants. Scott appealed to the Fourth Circuit and to the U.S. Supreme Court, but both declined to grant her the relief she sought. Undeterred, Ms. Scott proceeded to file her 4th claim against Mr. Moon. That suit filed on December 28, 2018, right after the other one was done. This is clearly harassing behavior. Again sought to invoke this court's diversity jurisdiction. Again, Ms. Scott listed a Pensacola, Florida address for Mr. Moon. She claimed in that case that Mr. Moon was committing the torts of invasion of privacy, appropriation, invasion of privacy, publication of private facts, defamation, and malice. She also claimed damages arising from emotional distress due to invasion of privacy and defamation. Uh-oh. That sounds like intentional infliction of emotional distress. That's claim preclusion. Bad Vibe says, hey, Melinda, you can't insult something that doesn't exist. Just saying. Aww. Okay. Notably, Ms. Scott's alleged damages significantly escalated again in her 4th suit. This time, she sought a grand total of $301,000 from Mr. Moon, in addition to injunctive relief ordering the removal of all content relating to her from the internet. This is a classic case of someone trying to use the courts to bully someone's behavior. This court dismissed Scott versus Moon on 1/24/2019. This court expressly noted that its decision was the 2nd dismissal of Ms. Scott's claims based on statements allegedly made on the same website. The court also noted for the 2nd time its serious concerns whether it had personal jurisdiction over the out-of-state defendants Ms. Scott was suing. As she is wont to do, Ms. Scott again appealed to the Fourth Circuit and to the Supreme Court of the United States. Both declined to grant her any relief. Ms. Scott's 5th claim against Mr. Moon is the instant case pending before this court, which was filed on July 8th, 2020. For the first time in this court, Ms. Scott listed an address in Fort Walton Beach, Florida for Mr. Moon. Also, for the first time, this court allowed her to file informa pauperis without simultaneously dismissing the complaint pursuant 28 USC 51915. In this 5th case, and that's very possibly because of her chosen defendants. And that's something to be said here. She's had different defendants in all of these. This case is not just against Joshua Moon, but it's against the Department of Child Protective Services in Wise County, Virginia. So she is suing government agencies in her state in federal court. All right? And that is likely why she was granted informa pauperis status and not immediately dismissed. The fact that Josh happened to be on the case was probably ignored because of the government defendants, and I'm guessing that's why this was not dismissed outright. Let someone make their claim against the government. It's much harder to harass a government agency than it is to harass an individual, and the courts might be willing to grant a little more leeway to someone exercising their fundamental rights against CPS. But when you include Josh Moon on there and he gets kind of roped into it, that is how a very unfair and very ridiculous filing can end up surviving. In this fifth case, oh shoot, General Isimo says, I mean, those lights that are just shooting out from the Lincoln Memorial along the reflecting pool is almost like extensions of Joe Biden's nose sniffing America. Thanks for being awesome, Nick. And come on, man. Lift up those arms so I can smell those pits. Don't wash your hair. Gross. Gross. In this fifth case, Ms. Scott asserted both diversity and federal question jurisdiction and repeated her previous claims that Mr. Moon had caused her emotional distress. And in this claim, Ms. Scott upped the ante again by increasing her demand for judgment to never-before-seen heights. In this litigation, she seeks judgments against multiple defendants in an aggregate total of $675,000. While Ms. Scott's visions of grandeur may have elevated her appraisal of her own damages from an initial claim in state court for $15,000 to a current claim in federal court for $675,000, the underlying merits of Ms. Scott's claims against Mr. Moon have not improved or even substantively changed since 2017. And this is the thing. Notice, this is someone who is filing informa pauperis, as in she has $0 to her name. The court has determined that she is destitute to the point of not being able to afford the lawsuit before her, which means how is she going to justify an economic loss of $675,000? She never had in her life $675,000 to lose. She has no demonstrated ability to earn $675,000. Even if you take everything as true, this amount is extremely, extremely questionable. She hasn't lost any property. She hasn't mentioned any lost economic opportunities. It's literally ma distress. She hasn't showed medical damages in anywhere near that amount. There's no way. There's no way. The underlying merits of Ms. Scott's claims against Mr. Moon have not improved or even substantively changed since 2017. Perhaps knowing the fate that would await her newest lawsuit if Mr. Moon was able to mount a defense, Ms. Scott elected in this suit to serve an electronic mailbox in Fort Walton Beach. She then proceeded to swear that Mr. Moon was properly served and to obtain an entry of default against him. Armed with entry of default, Ms. Scott felt invincible. She proceeded to file multiple motions to compel discovery from Mr. Moon. Now, normally, like this type of expositional speaking, right? Like, this is cute, telling a story, very narrative, very free and loose with the language. In a lot of cases, I would not recommend writing something like this into your suit. I think that would be a bad move in a serious lawsuit. This lawsuit is unserious. It is quintessentially unserious, and this is likely a call out to the judge. This is how fanciful and ludicrous this case is, that this lawyer who has written nothing but very professional documents, and this is a very professional document too. I'm not in any way besmirching this. This is, I don't know if it's actually a tactical decision, but it could very well be a tactical decision. He is pointing out, Judge, this is nonsense. It's such nonsense that I'm going to include this fluffy language just so you know how nonsensical it is. Move to strike Mr. Moon's efforts to seek relief from default. Move to require undersigned counsel to respond to her filings immediately and over the holiday. And even move for authorization to file electronically so she can more easily file additional motions without the necessity of paying postage. Unfortunately, in Miss Scott's flurry of recent filings, she has confessed she knowingly and intentionally did not serve Mr. Moon at what she alleges is his place of abode. She also attempts to use default, which she obtained through knowingly improper service and a selectively worded affidavit, to shield herself from any inquiry regarding the underlying factual or legal basis, which would serve as a good faith basis for her claims. This court should decline Miss Scott's invitation to turn a blind eye to her conduct. That's a good line right there. I really like that. But Miss Scott, if she were here, would say that she didn't know that the service was improper. But of course, she is going to argue from ignorance, and that argument is unavailing. She has a duty to know whether or not the service was proper, because she, as a pro se litigant, is obligating herself to follow the rules of the court to the same standard as a represented party. And she's not doing so. So she doesn't get to say, well, I didn't know that service to a mailbox that was an electronic mailbox where they don't live, for business address, where they're not even present, to people who don't work for them, was improper. How could I possibly know? You have a job to know. That's your obligation to know. Standard. Federal courts have, never mind. Federal courts have the inherent authority to punish a litigant for bad faith behavior, but they also have the inherent authority to regulate a litigant's behavior. Sanctions may be imposed under a court's inherent power for abusive litigation practices in any proceeding, civil or criminal. Quoting Chambers, courts therefore have inherent discretion to impose sanctions which are governed not by rule or statute, but by the control necessarily vested in courts to manage their own affairs so as to achieve the orderly and expeditious disposition of cases. The court's power to regulate conduct of litigants, including by issuing an order to show cause under its inherent power, is a separate issue from its authority to issue Rule 11 sanctions. Unlike Rule 11, which focuses on specific abuses and is not limited to willful conduct, the inherent power reaches all litigation misconduct done in bad faith. Because, quote, a finding of bad faith is sine qua non to the imposition of inherent power sanctions. This court must determine whether the plaintiff is acting in good faith or bad faith. If this court finds that the fraud has been practiced upon it or that a very temple of justice has been defiled, it is the power to take appropriate action. So here they have to determine that Melinda is actually acting in bad faith to impose any punishment. The order to show cause show that she's acting in good faith. Then there will be no sanctions. But if she's not acting in good faith, we want sanctions. And she's definitely not acting in good faith. Melinda is doing anything but. And that is pretty clear from everything about this case, is that she is not acting in good faith. Pursuant to its inherent powers, a court may impose sanctions against a plaintiff who has pursued a claim that is deemed to have been vexatious, wanton, or made in bad faith. But the question is not merely whether there was good faith at the time the claim was filed, because good faith is a continuing obligation of any litigant. The continuation of a claim which has become frivolous has been held to amount to bad faith. Further, if particularly egregious, the pursuant of a claim without reasonable inquiry into the underlying facts can be the basis for finding of bad faith. Break Contact 2 says, how long until you get another ethics complaint from this crazy lady? No, I don't think she'll send one to me. Also, I have a question about dealing with homeowners insurance. Can I email you about it? You can, but if you're not in Minnesota, I can't give you legal advice, but I can maybe point you to some resources. Argument. It appears from the face of Miss Scott's filing. And we're almost done with this document. From the face of Miss Scott's filings and from the entire record in this case, and in the records of her other cases against Mr. Moon, that Miss Scott may be acting in bad faith. Yeah, I think so. I think that's the nicest way he could have said this. Without reasonable inquiry into the factual or legal bases for her claims, or in a manner that is designed solely to escalate the costs of litigation. As previously indicated in other filings, at the appropriate juncture, Mr. Moon intends to file a motion under Rule 11 for relief. This, however, is not a sanctions motion. This is a motion to request that Miss Scott show cause, if any she has, how or why she's acted in good faith, or what basis she has to believe that her claims have any factual or legal support. Further, this is a motion to require Ms. Scott to explain her sudden decision to change the address she listed for Mr. Moon to Fort Walton Beach, even though she admits he is not domiciled there, in an attempt to obtain and enforce a default judgment from this court. And this is an interesting question. She has not presented any legally cognizable reason as to why he should be sued or why he should be served in Fort Walton Beach. Even if he literally worked in Fort Walton Beach, you would have to hand the papers to him personally at that place. That's how you could serve someone at their workplace, is by handing the papers to them personally. However, some states have rules as to how you can actually do that, because you're not allowed to harass someone by suing them at the workplace. And that typically involves contacting some sort of management and requesting, some sort of private delivery of those documents in person still, but maybe outside of the view of other employees, because states don't want people filing lawsuits at people's workplace and getting them in trouble. Ms. Scott should welcome the opportunity to show cause at a relatively early juncture in this litigation, before Mr. Moon's litigation costs escalate, just as Ms. Scott's claims have, from 5 to 6-figure territory. Similarly, this court should take the opportunity early in this litigation, which the plaintiff has already shown signs she intends to escalate or multiply, to evaluate whether there is any good faith basis for the claims which are being asserted. If the plaintiff is acting in good faith, this court need not resort to sanctions under its inherent power or under Rule 11. If the plaintiff is acting in good faith, defendant Moon need not trouble this court with the burden of adjudicating a Rule 11 motion of his own. This is, again, this is a warning shot. It's a warning shot to Melinda, and it's a bell ring to the judge, right? Here you go. If she doesn't do this, if she's unwilling to do this, we're filing Rule 11 sanctions and filing for sanctions under the inherent power of the court for bad faith action. We're going to do it. She can fix that right now in 2 ways. Withdraw from the litigation, probably. They haven't offered that specifically, but withdraw from the litigation would probably be one way to do it. The other way would be show that you have a good faith basis for your claim. Do it. And the court is probably going to want to deal with that. By contrast, if the plaintiff is acting in bad faith, as an increasing body of circumstantial evidence appears to show, this court will soon need to take appropriate action to impose sanctions under its inherent authority or Rule 11. This court cannot equitably impose sanctions without first issuing an order to show cause, however, or without giving Ms. Scott the opportunity to respond. Quote, due process requires in the absence of extraordinary circumstances, notice and an opportunity to be heard before sanctions are imposed. Notice of due process entails awareness of 1, the fact that sanctions are under consideration, 2, the reasons why they are under consideration, and 3, the type of sanctions being considered. This motion aims to do exactly that, to require Ms. Scott to respond to the concerns that her filings have raised. Defendant Moon respectfully submits that this case cries out for some sort of notice to Ms. Scott that her shifting legal and factual assertions have caught the attention of the court, that her efforts to obtain a default using service at an electronic mailbox that she asserts is separate from the defendant's place of abode have raised concerns. She said all this. This is the other problem. She's admitted that she has no idea. And since she's been notified and acknowledged that she did service wrong, her response should be to offer to serve properly. That's the appropriate response in this case. She never upheld that her service was actually proper. She alleged that it should be proper for reasons that are not legally sustainable. That's a big difference. That's a big difference. Let's see. So, is separate from the defendant's place of abode have raised concerns, and that her efforts to use a questionably obtained entry of default to shield herself from further inquiries has led to very plausible suspicions about the motives underlying this litigation and the way in which the plaintiff has conducted it. Further, even to the extent the plaintiff may have had good faith for initially filing this matter, this court should ensure that the plaintiff's vociferous opposition to setting aside the default, even in the face of obvious defects in service, is not in violation of the plaintiff's continuing duty of good faith as described in Davis versus Target Stores Division of Dayton Hudson. So again, they're she should have to defend her standing by this default judgment. She should have to back it up. Conclusion, this court should grant the motion for an order to show cause, which is filed at docket number 53. Respectfully submitted 19th day of January. Okay, Joshua Moon. Boom. So there we go. That is the update in Scott versus Moon. Now that all of the response and replies are in, hopefully they can get a ruling or a hearing on this matter very, very quickly. The other defendants all had their cases dismissed because they were actually served and were able to respond. Anthony James, no, I called this a lover's quarrel. No, I got that. I got that out of there. I understand that Melinda is fully in love with Josh. I get it. Josh just wants to feed her, though. Okay. Let's go ahead and find this thing. This video. Okay. Let's see this. Hold on 1 second. I've got it. Just a second. I'm going to go back just a hair in the video. I got to make sure the volume is up. All the way. Brothers, do you know the way? And this is on the right output. Okay. Here we go. Here we go.
Dr. Tony Fauci, our chief COVID medical advisor, Javier Becerra, excuse me, our nominee for Secretary of Health.
So just so you know my life, as
Dr.
we're waiting to do this, I just agreed to...
Dr. Rochelle Walensky, she's going to be the director for the Centers.
What was that? What was this? What was he doing? We'll go back. We'll go back. First of all, let me just say, this man's presence on camera is embarrassing. It's embarrassing. Here, I'll post it with the timestamp in the chat. Here you go. Yeah, I hear it's Hunter Biden is the allegation here.
19 team, response team, Dr. Tony Fauci, our chief COVID medical advisor, Javier Becerra, excuse me, our nominee for Secretary of Health.
So just so you know my life, as we're waiting to do this, I just agreed to...
Dr. Rochelle Walensky, she's going to be the director for the Senate.
That's on, I mean, this is the White House YouTube channel. Verified White House YouTube channel. I don't know what. Yeah, they muted that real fast. I can't believe they haven't taken this down and edited that out. Oh yeah, it's an unlisted video. They sort of took it down, but they didn't private it. Idiots. Idiots. Hold on. I just dropped it in the tweet. I had to do it. I said, good job, White House. Is that Hunter Biden? What plea deal? Where you at, media? Crickets. And then I dropped the timestamp. I cannot believe that. I can, of course, believe this. What am I talking about? Of course, I can believe this. Socialism is for Fig says match voice with an interview of Hunter, and by the way, with I think ABC interview of Hunter, and by the way, I'm a god. That's terrific. Did you find that? You didn't like drag that off of something? You sat and watched an hour and 16 minutes of Joe Biden talking? Oh my god. I've posted the link several times. It's also on my Twitter, but here. Here it is in the chat. It's spammed. You can, it was shared to you? Okay. So there you go. That's what's going on with that. That's an interesting development.
Sarah.
Sarah, the man is terrible. Terrible at a podium, terrible on camera. Look at he's all slouchy. He's all slight, just like Obama. Like, look, I'm not a big guy. I'm not saying you have to be a big guy, but you got to get your look right. And this look is so meek. And the worst thing, I think, is that they want meekness to exude from this president. Like the soy that would drip out of him if you squeezed him. Gross. How embarrassing. For us, by the way. We're the embarrassed ones in this case. Ugh. Don't worry. I'm not mentioning your name at all. Boer 135. Lucas B. Smith. Yeah, I'm 6'2", but I'm not like a big wide guy. Like Drexel, his shoulders are, you know, like a foot wider than mine. I'm tall, but I'm not big. I'm not like big and built and muscular or anything like that. I'm a wuss. Like Vince Vaughn. Managed to somehow genetically stay rather thin despite having 0% muscle mass. It's perfect. What could it be about? I mean, if it is Hunter, which I'll take your word on matching the voice. If it is Hunter, it could have something to do with Ukraine. Who knows? I mean, if he took a plea deal in the U.S., you'd think that would be in a public filing somewhere. Yeah, the reason I get this all the time, people are like, whoa, you're 6'2", and when they see me in person, they're like, oh my god, you're a lot bigger than I thought. It's because I'm sitting, my camera's up above me at a downward angle, so I look shorter on camera. I look small. SMOL small. Tee. But no, I'm actually fairly tall. So yeah, Angry Baneling, I'm statistically likely to be taller than you already. Okay. That being said, let's get to this Parler document. Because I want to also get to Twitter being a haven of pedophiles and child pornography. Because Twitter and Jack Dorsey love child pornography. Jack, sue me on that. Absolute garbage people. The worst people on earth. First of all, they have their savior complex that they get, well, we want to control a global conversation between people. And then, of course, they like kid porn. So, Bad Vibe says, String Bean Esquire confirmed. Yeah, exactly. Can I share the link? What, to this document? The Parlor Twitter document? Which document, Klutz? No, I'm not using the cheese pizza euphemism. Twitter supports and endorses and circulates child pornography. Twitter, LLC Incorporated, whatever it is, loves, endorses, and fully supports child pornography. They try to put up an air of not supporting it by eventually taking it down after repeated reports that are hours, days, or even weeks old. They will take down political hate speech in a matter of minutes, but they will keep child pornography intentionally up for a significant amount of time because Twitter wants to distribute child pornography for advertising revenue. Period. The White House live stream. I mean, I've posted it like 50 times, but here you go. All right. Yeah. This is a $5 chat, but I'm going to address it now while I'm pissed off. Kidda says, the U.S. military has entered Syria. It didn't take them 24 hours to put us back at war. Not even a day. Not even a day. Big Red Bear says, I didn't realize that Twitter was such a big player in the anime distribution market. It's not anime. We're talking real kids. We're talking real kids. Yeah, get used to this. You thought the 4 years without new war was nice. It was good. There was some early on weird conflict stuff I disagreed with Trump on. I didn't like the missiles he fired at Damascus or whatever. Or it wasn't at Damascus. It was at the Air Force Base in Syria. They fired, the missiles at and stuff like that. I didn't like that. I didn't want military action. Yet, it happened, and then nothing else. Like the amount of military action. And think about this. Think about how the media has been covering military actions since 9/11. The majority of my adult life, they've been covering military actions largely the same. It disappeared under Trump. It just wasn't any to cover. Sure, we had some soldier presence. Oh, and remember this. Trump's own military advisors were literally lying to him about troop levels to make him think he had reduced troop numbers while keeping them over there. Actual traitors to the commander-in-chief. Actual traitors to this country. Lying to their commander-in-chief, direct insubordination about troop levels. And laughing about it. But the media didn't report much of any of that, and still we had a reduction in foreign conflict. Do you guys not know about that? I'm seeing a couple people in the chat who seems like that's a news story. Oh, yeah. Are they prosecuted? No. Of course not. It was amazing. Amazing. And the media was so happy with it. These people love war. They love war and death. Death of our soldiers. They love when our soldiers kill brown people overseas. They love making our soldiers kill brown people. They love it. The media thrives in war. It's the easiest coverage in the world. They just send some guy over. Maybe he gets beheaded and they're happy about that. Yes, they're happy about that. Their ratings go through the roof when a journalist gets killed by an ISIS. They love violence, blood, death, and pain because it sells news. It sells ads to Pfizer. Buy your Viagra, get your vaccination. Right? Hey, Pfizer, advertise on my stream. We need some blue pills, I think. That's a joke. That's a joke. All right. So this is Parler versus Amazon. Remember, this is the hateful speech, okay? And we've got an order denying a motion for preliminary injunction. Ace of Spades, you're right. I would run a Pfizer ad. It cost them a lot, but I'd do it. Introduction. This matter comes before the court. Oh, yeah. So this is their, if I didn't mention it, denying their motion for a preliminary injunction. This is not the end of the case, but it may effectively be the end of Parler. I don't know. Parler's been showing some signs. Here, I'll pull up the website that they're making an attempt to come back. Here we go. They have a statement up today. Let's check this out. Oh, they have a statement on this ruling. Oh, it's Sean Hannity. Parler's a great American. We are disappointed by the judge's ruling against our request for a preliminary injunction in our suit against Amazon. We remain confident that we will ultimately prevail in the main case. Oh, Parler. Honey. Booby. Cute stuff. We also remind everyone that this litigation is still in its early stages and that the resolution of this case will have broad implications for our pluralistic society. They better find a way to get up and running because this case has years of time written on it. Parler is gratified that the court refused to uncritically accept Amazon's argument, widely repeated in the media, that the Parler platform was somehow used to plan or coordinate or execute the despicable January 6th riot at the Capitol. I mean, wait! What? What statement is that? What decision did you... Remember this line when we go through this document in just a minute. Based on the evidence of which we are aware, the Parler platform was not used in that manner, even though competing platforms clearly were used for that purpose. We're grateful for the court refused to join the dishonest attempt to make Parler the scapegoat for the riot. I mean, let me just give you a spoiler alert on this. Here's a spoiler alert. This court explicitly rejects any suggestion that the balance of equities or the public interest favors obligating Amazon to host the kind of abusive, violent rhetoric content at issue in this case, particularly in light of the recent riots at the U.S. Capitol. That event was a tragic reminder that inflammatory rhetoric can, more swiftly and easily than many of us would have hoped, turn a lawful protest into a violent insurrection. The court rejects any suggestion that the public interest favors requiring Amazon to host incendiary speech that the record shows some of Parler's users have engaged in. What decision did they read? At the same time, Parler is disappointed that the court's ruling ignored the reality that every social media platform, including Amazon's own online store, sometimes unwittingly hosts content that incites violence or is otherwise inappropriate. In fact, our analysis shows that the incidence of such material on Parler is far lower than on competing platforms. Parler has developed an AI-based enforcement system that we believe will reduce the incidence of such content still further. Parler looks forward to working with old and new partners to reestablish an alternative social media platform that not only avoids the unnecessary censorship that has become increasingly popular with its competitors, but is also more protective of public safety. There it is. There's the more protective of public safety, AI censorship. They're not, when they come back, if they come back at all, we'll see. Over the past few weeks, Parler has been repeatedly mischaracterized and treated unjustly, but the recent personal attacks on our CEO John, his wife Alina, and their family are reprehensible. Alina, whose working class family lived in the former Soviet Union, came to America to start her own multiracial interfaith family with John, to subject them to baseless accusations that their marriage is part of some twisted espionage scheme, all because she's an immigrant, is precisely the sort of racism, nativism, fear, and demonization President Biden urged us to reject in his inaugural address. The entire Parlor team stands behind John and Alina. Our new president called for unity. We must end this uncivil war that pits red against blue. Stop using uncivil war. Stop. It pits red against blue, rural versus urban, conservative versus liberal. We can do this if we open our souls instead of hardening our hearts. The smears against John and Alina are exactly the sort of tactics he is imploring us all to abandon. Let's all commit to working together towards unity and healing. And whoever just said, let's see, Fappa Lappa says cringe. Cringe is right. We've got to stop acquiescing to the marketing of uncivil war. That is not at all acceptable. All right, this matter comes before the court on a motion for temporary restraining order filed by plaintiff Parler. Parler is seeking to have the court order defendants Amazon to reinstate their web hosting services that Amazon provided Parler under the parties' customer services agreement. Parler initially filed the motion as one requesting a TRO, but after the court ordered Parler to serve AWS notice, ordered additional briefing, and held a hearing, the parties agree that the motion has been converted to one for a preliminary injunction. They're the same standard, so it doesn't matter. It's just a matter of labels. In its complaint, Parler asserts 3 claims. One for conspiracy and restraint of trade in violation of the Sherman Act. Oh, shoot, there's a big chat. 1 second. For breach of contract and for tortious interference with business expectancy. Amazon disputes all 3 claims, asserting that it is Parler, not Amazon, that has violated the terms of the parties' agreement, and in particular, Amazon's acceptable use policy, which prohibits the illegal, harmful, or offensive use of Amazon's services. All right, Bad Vibe says, what happens when a lawyer/politician takes Viagra? They get taller. That's a good dad joke right there. I like that one. And then OR2891 says, good evening, Nick. Hey, thank you for the big chat, buddy. Was going to send a funny chat, but news of Syria has me seething. Literally what Americans should seethe about. Lost a high school friend to an IED. Friend's cousin still lives with PTSD. He lost his wife and child over. Yeah. War is real. It's a real issue, and for many of us out here, war was a real issue as to why we voted for Trump for re-election. Because you don't know, if you're not aware of the story, I did not vote for Trump in his first term. I thought that based on what Trump said on the campaign trail, I didn't vote for Hillary either. Let's not be too hasty. I voted for me. I could not vote in the 2016 election. I felt I could not vote in good conscience for either party. Now, the reasons I didn't vote for Trump were because he made specific statements during his campaign that had me concerned about freedom of speech, freedom of press, and frankly, about war. Now, during his term of 4 years, he did none of those things in any capacity, even to the extent of his predecessor presidents. So I did not see Trump trampling on speech. I did not see Trump trampling on the press. I mean, he argued with the press. He made fun of Jim Acosta. And frankly, who doesn't need to make fun of Jim Acosta? If there's any member of the press that deserves ridicule, Jim Acosta is high on the guest list. He made fun of people. That's about it. He made them feel bad because they are bad. They're bad people. And he laid that out flat on the floor. Never was ever dishonest about it. But he didn't jail them, he didn't arrest them, and he did nothing to silence them. He alleviated my concerns, and most importantly, we were not in a new war for 4 years, and there was a decrease in military action, at least as far as I could tell. And the economy, until COVID, was doing relatively well. So he earned my vote. He earned it. And now, instead, we get a warmonger. And I don't think Joe Biden's a warmonger. I think his handlers are warmongers. And I think his sycophantic media are warmongers. They want our men and women to go die and shoot brown people. That's what they want, because that's what sells ads. Jeremy Griffin says, first time griftee. Arch Warhammer just got his channel back. Jeremy, thank you. And that is fantastic. Arch did not deserve what happened to him. And the fact that YouTube took so long to get back to him is part of the issue. It's part of the issue with YouTube. And I hope it wasn't malicious. There's plenty of reasons to think it might have been. But hopefully it was just he got hit at a really bad time. And I can tell you my contacts with YouTube through December and the beginning 2/3 of January have been pretty tough. It's been hard to get a hold of YouTube, even when you have very good contacts there. They've been busy. So hopefully that was the case. But that really sucks that happened to Arch. And everybody, if you love Warhammer stuff, go check out Arch. Go check him out. He's an interesting guy. Puts out good content. Some people don't like it, but, you know, lots of people do. Okay. Here we go. It is important to note that what this case is not about. Parler is not asserting a violation of any First Amendment rights, which exists only against a governmental entity and not against a private company like Amazon. And indeed, Parler has not disputed that at least some of the abusive and violent posts that gave rise to the issues in this case violate their acceptable use policy. And this is the death knell. This is what killed their case. It's what killed their motion for a preliminary injunction. And it's maybe what ends up killing the case entirely. In my opinion, Parler should have considered that these were not violations of the acceptable use policy, or that they didn't believe them to be. But they decided to acquiesce to Amazon's request in an effort to further understand the acceptable use policy going forward and better attempt to comply with it. Something like that. This admission alone may have killed the case entirely. This motion also does not ask the court to make a final ruling on the merits of Parler's claims. As a motion for preliminary injunction before any discovery has been conducted, Parler seeks only to have the court determine the likelihood that Parler will ultimately prevail on its claims. And they've determined this, by the way. And to order Amazon to restore services to Parler pending a full and fair litigation of the issues raised in the complaint. Having reviewed the briefs filed in support of and in opposition to the motion, and having heard oral arguments by video conference, the court finds and rules as follows. Background. Parler was founded in 2018, describes itself as a conservative microblogging alternative to competitor Twitter. Parler, like Twitter, Facebook, and other social media entities referenced in this action, is an online platform that allows third-party users, sometimes anonymously, to express thoughts and ideas for other users to read and comment on. Parler takes a laissez-faire or reactive approach to moderation of its users' speech. By the way, so does every platform in some way or another. Some are just more laissez-faire than others. Like, some infringing speech on Twitter and Facebook is quickly handled by an AI. But not all. Not all. D Grubs MD667 says, did Parler consult with Melinda Scott for legal counsel? Jesus. Look, Parler did they made the quote-unquote mistake of trying to be relatively honest. Because they didn't think in any world a judge would go, oh yeah, shutting down a company, that's not less damaging than someone might post a comment that might not get moderated. But here we are. We've got a judge who was born before World War II deciding a matter of internet communications that the judge very possibly doesn't understand. That's not a slight to people born before World War II, by the way. Many of them are tech savvy. I don't have faith that judges are, because judges don't often engage in social media. There's a big difference between what a judge's life is like and what a normal person's life is like, because judges aren't really allowed to express their opinions publicly as is. They could expose themselves to making a public statement that would be seen as an opinion that would prejudice a client before, or a case before their court. So they can't really do it. So they don't do it. You notice there aren't a lot of judge social media accounts around, and the ones that may exist, I'm not aware of any, aren't very popular. They don't have experience with this. At the time, quote, we prefer that removing community members or member-provided content can be kept to the absolute minimum, and it should be. At the time of the filing of its complaint, Parler claims to have had 15 million end-user accounts and 1 million downloads of its app per day. Amazon and Amazon.com, or AWS and Amazon.com Incorporated Company, offers computing services for businesses, nonprofits, and governmental organizations globally. According to Parler, Amazon is the world's leading cloud service providers, capturing a third of the global market. Parler entered in a third of the global market. Parler entered into a customer services agreement with Amazon for the latter to provide the cloud computing services Parler needs for its apps and website to function on the internet. In recent months, Parler's popularity has grown rapidly, and around the time of the 2020 presidential election, according to Parler, millions of users were abandoning Twitter and migrating to the Parler platform. During the same period, Amazon claims that it received reports that Parler was failing to moderate posts that encouraged and incited violence in violation of the terms of the CSA and AWS's acceptable use policy. The acceptable use policy prescribes, among other things, illegal, harmful, or offensive use or content, defined as content that is defamatory, obscene, abusive, invasive of privacy, or otherwise objectionable. You hear that? No defamatory content allowed on Amazon Web Services. None. They don't take down defamatory content. They don't at all take down defamatory content. Amazon claims that in recent weeks it repeatedly communicated with Parler its concerns about third-party content that violated the terms of the CSA and AUP, and that Parler failed to respond to those concerns in a timely or adequate manner. I believe their response was 48 hours. Amazon has submitted to the court multiple representative examples reflecting content posted on Parler during this period that Amazon claims violated the terms of the acceptable use policy and the parties' agreement. This court will not dignify or amplify these posts by quoting them here. Uh-oh, Parler, you're going to lose. You're going to lose. I'm telling you now. Parler has not denied that these posts are abusive or that they violate the acceptable use policy. Parler does claim, however, that Amazon knew Parler was attempting to address content moderation challenges and that Amazon appeared to be willing to cooperate in Parler's efforts. Asserting Amazon's actions and communications led Parler's corporate officers to believe that far from being concerned about remaining in a contractual relationship, Amazon wished to extend that contractual relationship. On January 6th, supporters of President Donald Trump seeking to overturn the results of the presidential election marched on Congress, resulting in a violent and deadly riot at the U.S. Capitol. On January 8th, Twitter and Facebook banned President Trump from their platforms. Parler claims that in response to speculation that the president would move to Parler, there was a mass exodus of users from Twitter and Parler and a 355% increase in installations of Parler's app. Parler also claims that the surge during this time was responsible for its failure to deal with a backlog of some 26,000 posts that it acknowledges had potentially encouraged violence in violation of the AUP. Acknowledging, so then they quote the representation. On January 9th, Amazon notified Parler that it intended to suspend all services as of 11:59 p.m. on January 10th. Exhibit 1. Let's see. Quote, it's clear that Parler does not have an effective process to comply with the Amazon terms of service. Given the unfortunate events that transpired this week in Washington, D.C., there's serious risk that this type of content will further incite violence. Because Parler cannot comply with our terms of service and poses a very real risk to public safety, we plan to suspend Parler's account effectively Sunday, January 10th. At some time during the night between January 10th and 11th, Amazon suspended its services and Parler went dark. One thing that Parler maybe didn't do very well in this, Amazon was offering their AI moderation services, and Parler hadn't bought yet, and Amazon suspended them after they didn't buy it, but had discussed buying it. Like, this is an anti-competitive practice. It's an abuse of trust. This is what the Sherman Antitrust Act was made to prevent. Was, look, buy our services or else we'll kill your business. Literally a mobster's bargain. Had Parler purchased Amazon's services, their AI moderation services, it's very likely that much of the content that they posted would remain up for the same amount of time that it did. Because remember, those 26,000, they had dealt with 25,000 of them in under 48 hours and would have the rest of them dealt with by 48 or 50 hours. I can't remember what they actually said. But Amazon literally did the mobster's bargain. Look, hey, you want to stay in business, you got to pay the fee. You got to pay for security, Come on. This is how it's done. It's how we do it. I don't know if I think Parler maybe could have, in hindsight, Parler maybe could have hammered on that a little harder. That this is retaliatory for them not immediately agreeing to implement Amazon's AI. That they were using this suspension as punitive action for not increasing the amount of money that Amazon would make. That might have made a better claim. Sometime during the night between January 10th and 11th, Amazon suspended its services and Parler went dark. I think it was 2:04 a.m. Central Time. On the morning of January 11th, Parler filed its complaint in the instant motion, seeking ex parte a TRO from this court prohibiting Amazon from suspending services. Parler failed, however, to provide the certification required under the federal rules, verifying that its counsel made an effort to serve Amazon's notice of the motion, or in an alternative, why notice should not be required. The court therefore ordered Parler to provide notice. Further, the court set a briefing schedule as directed. Amazon filed its opposition on January 12th. Parler filed a reply on January 13th. On January 14th, the court held a hearing on the motion by video conference. The court and the parties agree that a motion for temporary restraining order is now essentially one for preliminary injunction and it's ripe for this court's consideration. Okay, there's the background. By the way, I'm drinking 1792 full proof bourbon, which was a gift from my man Ryan. Thank you for that. Okay. Standard for a preliminary injunction. So the court's going to tell us the standard, and then they're going to tell us why Parler failed. As courts have repeatedly emphasized, an injunction represents an extraordinary remedy that is never awarded as a matter of right. For a preliminary injunction to issue, the moving party has the burden of demonstrating all four of the following elements: that it is likely to succeed on the merits, that it is likely to suffer irreparable harm in the absence of preliminary relief, the balance of equities tips in its favor, and that an injunction serves the public interest. In the wake of Winter, in which the Supreme Court narrowed the path to an injunction, the Ninth Circuit has maintained that a preliminary injunction, quote, may also be appropriate if movement raises serious questions going to the merits and the balance of hardships tips sharply towards it, as long as the second and third Winter factors are satisfied. Okay, so they don't have to do the likely to succeed on the merits if they can show the balance of hardships tipping sharply towards it. And again, any reasonable read of the situation, in my opinion, shows that the balance of hardships tip sharply towards Parler. Now, I do think there's serious questions going to the merits. I think there's bad faith in this upholding of this agreement, and I think they should maybe have hit on which I talked about in the previous review of their documents. They didn't really hit very hard on the Washington state requirement for good faith and fair dealing in contracts. Whereas Amazon technically has a duty to attempt to make the contract work. But they didn't hit that very hard in their filing. I don't know why they didn't. I'm not their lawyer. I don't know if that was strategic. I don't know if they omitted that. I don't know. But they clearly have that they're going to suffer irreparable harm, and that the balance of, and that, let's see, second and third winter are satisfied that the balance of equities tips in his favor. Oh, yeah, it would tip sharply in their favor if it tipped in their favor. So that's easy enough. Okay. Further, in the Ninth Circuit, the elements of the preliminary injunction test are balanced so that a stronger showing of one element may offset a weaker showing of another. Likelihood of success on the merits. Parler's motion asserts 3 distinct claims, and the court reviews each in turn. Dallin, if they don't win, they're probably dead. They're probably dead. Parler alleges that Amazon's termination of service is apparently designed to reduce competition in the microblogging services market to the benefit of Twitter, and therefore violates Section 1 of the Sherman Act. Quoting the act, prohibiting every contract combination in the form of trust or otherwise or conspiracy and restraint of trade or commerce. To prove a violation of Section 1, Parler must show the existence of an agreement and that the agreement was unreasonable restraint of trade. At this stage in the proceedings, Parler has failed to demonstrate that it is likely to succeed on the merits of its Sherman Act claim. And I mentioned this. I mentioned this in the initial read. They didn't really shore up the agreement between Amazon and Twitter and link it to Amazon's action. They allude to it. It's vaguely stated, and maybe they were going for candor before the court because they don't have strong evidence supporting it. They thought they could get it on discovery. They should have probably just gone balls to the wall and stated it. Stated that Amazon and Parler and Twitter have an agreement, and that once Parler became a threat to Amazon or to Twitter, that Amazon went ahead and used that agreement as basis for snuffing out Parler as competition to Twitter. They do all but say that directly. I think they should have stated it specifically and explicitly in their thing. If you're going to make the allegation, just make it. While Parler has not yet had an opportunity to conduct discovery, the evidence it has submitted in support of the claim is both dwindlingly slight and disputed by Amazon. No, we're not a trust. Importantly, Parler has submitted no evidence that Amazon and Twitter acted together intentionally or even at all in restraint of trade. Not only did they support no evidence of this, they didn't flat out say it. They tried to make people get to that idea. And they just have to allege credibly that there's an agreement that has this restraint of trade, or that the existence of their recent agreement is this restraint of trade. So, quote, so they're quoting Bell Atlantic versus Twombly. Remember I said in the last case, Iqbal Twombly. The two cases are Bell Atlantic versus Twombly, and then Iqbal versus Ashcroft. Bell Atlantic versus Twombly was an antitrust case in which someone was suing Bell Atlantic Corporation for being basically a monopoly in the phone services businesses. Let's be very clear about this. Bell Atlantic was operating in violation of the Antitrust Act. They absolutely were. Bell Atlantic was a monopoly and was acting in an agreement with other companies in restraint of trade and competition. That is happening, was happening, is still happening. The problem with the case was Twombly could not credibly assert any sort of meetings, dates, phone calls, letters that had been exchanged between Bell Atlantic and its competitors. But you tell me that telecommunication companies don't act in anti-competitive matters? You try and honestly convince me of that, and I'll give you a medal of some sort. You just tell me why you only have one, maybe two options where you live for internet or phone services. This guy just didn't have access to any documents that supported his allegation, even though his allegations were right. Okay, an allegation of parallel conduct and a bare assertion of conspiracy will not suffice. So he asserted it, and he alleged it, but he couldn't provide any details. And of course, how could you? These deals are made on golf courses with nothing written down. Hey, we're moving into Detroit. You know, we'll take the Northwest Quarter. We'll drop it down if you guys want to stay out of there. that's fine. That would be lovely. And then we'll stay out of the southeast quarter, that way, we wouldn't want to get into a price war. Price wars are just ugly for people. What-tink? That's how those deals happen. In contrast, Amazon has submitted the sworn declaration of an executive explicitly denying the existence of any such agreement. To my knowledge, Amazon and Twitter have never discussed, much less agreed upon, any policy, practice, or act directed at Parler. To the contrary, we have an internal policy never to discuss matters involving one customer with another customer. Oh yeah, they never happen. They never happen. Nobody in my organization would be authorized to discuss Parler with Twitter without my authorization, knowledge, or involvement. I've not authorized any Amazon employee to discuss Parler with Twitter, and I have not been involved personally in any such discussion. There you go. Sure thing. Absolutely. Indeed, Parler has failed to do, and never mind. I'm not going to go farther. Indeed, Parler has failed to do more than raise the specter of preferential treatment of Twitter by Amazon. Some of its allegation is that by pulling the plug on Parler but leaving Twitter alone despite identical conduct by users on both sites, Amazon reveals that its express reasons for suspending Parler's account are but pretext. Yes. But Parler and Twitter are not similarly situated because Amazon does not provide online hosting services to Twitter. Really? Let's see. Here we go. Twitter signs new hosting deal with Amazon Web Services, which could help facilitate new updates. Published December 15th, 2020. Twitter has signed a new hosting deal with Amazon Web Services, which will enable it to utilize the capacity of Amazon to improve the app's performance and the services it's able to provide. As reported by Bloomberg, under a multi-year deal announced on Tuesday, Twitter will use Amazon Unit to provide global cloud infrastructure to deliver Twitter timelines, supplementing the social media company's own computing capacity. Companies didn't disclose financial terms of the deal. Twitter was forced to ease back the launch of fleets due to major issues with system load, which lead to significant lag and poor user experience. Those issues have been sorted now, but the new arrangement with Amazon Web Services could help Twitter avoid the same future releases and updates. Amazon does not provide online hosting services to Twitter. Good job, Judge! By the way, this was alleged specifically in the case with citations to these articles. Parler adequately pled this. Parler adequately pled that Amazon does provide online hosting services to Twitter, as announced in major media. Parler's unsupported allegation that Amazon provides online hosting services to both Parler and Twitter is explicitly denied in a sworn declaration by an Amazon executive. Twitter's principal social media services does not run on Amazon. On December 15th, Amazon announced that it signed an agreement with Twitter for Amazon to begin servicing the Twitter feed for the first time. We do not yet service the Twitter feed, and I'm not aware of any particular timeline for doing so. It's fine. They're not doing it now. They just have a contract to do it. They just signed an agreement, announced it publicly on December 15th, admitted to it in court, but they're not doing it though. So therefore, Parler's wrong in saying that they're doing it. Thus, as Amazon asserts, it could not have suspended access to Twitter's content because it does not host Twitter. Actually, it could. It still could go ahead and suspend or terminate its contract. It absolutely can. Amazon, their terms, as according to Parler here, their terms require compliance with the users of Twitter to follow Amazon's acceptable use policy. It doesn't say follow users of Twitter or users of Parler who use the services exclusively provided by Amazon and no one else, all users must acquiesce to the acceptable use policy. Unless Twitter got a different deal, which maybe they did. Maybe they did. Because the Twitter feed does not run on Amazon, the Twitter feed and any tweets on the Twitter feed are not subject to and thus cannot violate Amazon's acceptable use policy. Yeah, actually, I don't think this is supported by the language of the contract, personally. But that's me. I mean, Amazon gets to enforce its contract however it wants. But I think under an honest read, they do. In short, Parler has proffered only faint and factually inaccurate speculation in support of a Sherman Act violation. And again, to be clear, while I think this judge is ridiculous on these reasons, I don't think Parler adequately pled the antitrust stuff, as I stated in my initial breakdown of the complaint. Amazon, in contrast, has submitted sworn testimony disputing Parler's allegations. Parler therefore has failed to demonstrate at this stage a likelihood of success on its Sherman Act claim. Now here is their stronger claim, the breach of contract claim. Good night, Siren. Says, the gravamen of Parler's breach of contract claim is that Amazon terminated the agreement without providing Parler 30 days secure on any alleged material breach. Amazon denies that it terminated Parler's account, claiming it merely suspended its services. As discussed below, this distinction is not material to Parler's claim at this stage. However, as the CSA grants Amazon the authority to take either action under the same circumstances. Parler claims it is entitled to the 30-day cure period based on a provision in the customer service agreement that provides, quote, either party may terminate this agreement for cause if the other party is in material breach of this agreement and the material breach remains uncured for a period of 30 days from receipt of notice by the other party. As noted above, Parler alleges that Amazon notified Parler that the latter was in material breach for the first time only hours before suspending or terminating services. Amazon responds that it is Parler, not Amazon, that has breached the agreement in particular. Amazon claims that Parler breached Section 4.2 of the Act, or of the agreement, which requires Parler to, quote, ensure that Parler's content and Parler's end user Parler's and end users' use of Parler's content will not violate any of the policies. Now remember, the judge just above accepted the argument that certain content on Twitter was not subject to Amazon's thing. But the actual agreement says content, Parler's content, and Parler's end users' use of Parler's content. Not content specifically hosted by Amazon. That AUP, as noted above, prescribes activities that are illegal, that violate the rights of others, that may be harmful to others, our operations or reputation, and content that is defamatory, obscene, abusive, invasive of privacy, or otherwise objectionable. Amazon cites multiple examples of content posted on Parler's site that undeniably meet this definition. Parler has not denied that content posted on its platform violated the terms of the CSA and the AUP, claims only that Amazon failed to provide notice to Parler that Parler was in breach and give 30 days as a cure. This Parler claims is required per Section 7.2bi. However, Parler fails to acknowledge, let alone dispute, that Section 7.2b2, and they should have focused on this more. Provision immediately following authorizes Amazon to terminate the agreement immediately upon notice and without providing any opportunity to cure if Amazon has the right to suspend under Section 6. This is all, the way this is written is illusory. It's not an actual promise. We have to give you 30 days to cure for notice unless we decide that we don't. That's what it says. That's what it says. And it's completely ridiculous that that would be an agreement that could be operated under with any sort of confidence or capacity. And it's written by Amazon and not negotiable by the end user, so it should be read strictly against Amazon, and those two terms are in conflict. And Parler should have argued that. They may not have won on the argument, but they should have. It's an adhesion contract. It's a contract that they have to agree to without the ability to negotiate, and those are quote-unquote disfavored by the courts. However, they seem to be favored just fine, but that's what the courts say. And Section 6 provides in turn that Amazon may suspend Parler or its end users' rights to access or use any portion or all of the service offerings immediately upon notice for a number of reasons, including if Amazon determines that Parler is in breach of this agreement. So, literally, if we're saying you're in breach for cause, we have to give you 30 days. But if we determine you're in breach, we don't. Think about that provision. Like, let's say you have a car payment, okay? You have a car payment, and your car payment contract says, look, if you're late on your payments, you will receive a notice of default payment, and you will have 30 days to cure your default payment. And then in the subsequent section, it says, we may actually suspend and terminate this agreement and reclaim the car or demand payment in full if we determine you're in breach for any number of reasons listed above. You may be in breach for being in default of payment. Well, what use is that 30-day portion? It's of no use. It's of no use, or it's in conflict. And to me, this borders on an unconscionable sort of thing. To include our determination of breach allows us to terminate immediately and not be in breach. Okay, there you go. Causing irreparable harm. And sure, you could sue them for breach, but it's going to cause irreparable harm to your company, and you won't be able to sue for breach. It's a mess. Okay, sorry. I really hate these types of contracts. Big tech is all about them. And they put all of the power in the hands of big tech, and you don't get to negotiate them. You might if you're a multi-billion-dollar company, but outside of that, you don't. In short, the CSA gives Amazon the right to either suspend or to terminate immediately upon notice in the event Parler is in breach. Nope. In the event that Amazon determines Parler is in breach. Parler has not denied that at the time Amazon invoked its termination or suspension rights, the Parler was in violation of the agreement and the AUP. Again, they should have denied this. They should have said that they were actually in the process, they were complying with the breach. They were complying with the terms of the agreement, that they were taking reasonable measures to address the violations. They should have, and again, this is hindsight. You know, how you write a case varies dramatically, and it's easy to say this reading it now that we have the answer. But this is over and over what we're seeing the judge go back to. Parler didn't deny that they were in breach. Parler should have said, we were not in breach. Our understanding of the terms was that we had to take measures to prevent end users from doing this. But under any system, these things take more than an instant amount of time. And as Amazon expressed that we were not doing it fast enough, we were actively still removing content that may have been in violation in honor of our end of the agreement, and that we were working with Amazon to develop a more specific and successful, faster service level. That's what they should have said, something along those lines. They should have denied that they were in breach of the agreement, or that the content was violated, or that their actions in policing the content violated the policy. They should have denied it harder. Okay. It has therefore failed at this stage in the proceedings to demonstrate a likelihood of success on its breach of contract claim. Intentional interference with business expectancy claim. This is the weakest one, in my opinion. Although Parler makes a good case for it in their thing, not good enough, obviously. Under Washington law, in order to establish a tortious interference claim, Parler must prove 1. The existence of a valid contractual relationship or business expectancy. The defendants had knowledge of that relationship. An intentional interference inducing or causing a breach or termination of the relationship or expectancy. The defendants interfered for an improper purpose or used improper means, and resulting damage. They're going to really get hung up on 4 here. They're going to say they shouldn't be required to host this stuff, and that a breach of contract is not an improper means to terminate. That's what they're going to say. Exercising good faith, one's legal interest is not improper interference. There you go. If there's a breach of contract, you get to enforce that, and that's not improper interference. Parler has failed to allege the basic facts that would support several elements of this claim. Most fatally, as discussed above, it has failed to raise more than the scantest speculation that Amazon's actions were taken for an improper purpose or by improper means. Well, except for the fact they allege that Amazon did it while they were in breach and that they were in violation of the Sherman Antitrust Act. I mean, they did allege that, but not well enough. Conversely, Amazon has denied that it acted improperly. We reviewed our own behavior and we found that we did nothing wrong. Justifying its actions as a lawful exercise of its rights, it had pursuant either to the suspension or the termination of services provisions of the customer service agreement. Further, for the reasons outlined, Parler has failed to demonstrate the likelihood that Amazon breached the customer services agreement. To the contrary, the evidence to this point suggests that Amazon's termination was in response to Parler's material breach. Parler has therefore not demonstrated a likelihood of success on the claim, and this goes right back to this. Parler has not denied. Irreparable injury. Because likelihood of success is a threshold inquiry, when a plaintiff has failed to show the likelihood of success on the merits, the court need not consider the remaining three winter elements. Given the gravity of the issues presented, this court nevertheless will do so. As noted above, a plaintiff seeking a preliminary injunction must establish that it is likely to suffer irreparable harm in the absence of preliminary relief. Importantly, a showing of a mere possibility of harm is not enough. Irreparable injury is traditionally defined as harm for which there is no adequate legal remedy, such as an award of damages. In support of its claim to irreparable injury, here we're going to find out how dumb this judge is in just a second, okay? Parler alleges that Amazon's suspension or termination renders Parler unable to deliver the services it promises its users and entirely unable to function online. Furthermore, Parler claims the actions are a direct blow to its mission and reputation and has caused a loss of user loyalty, advertising revenue, and the ability to raise capital. In short, Parler alleges these actions have threatened it with extinction. The injuries Parler alleges in its complaint and its motion may be irreparable. The threat of being driven out of business is sufficient to establish irreparable harm. But in winter, the Supreme Court explicitly rejected the possibility of irreparable harm as too lenient to support a preliminary injunction, and the hearing the court held on this motion. Amazon vigorously disputed that Parler has shown that its extinction is likely in the absence of an injunction. They didn't say they were going to go out of business hard enough. They said they weren't going to go out of business hard enough. The court makes no finding on this issue, but notes that Parler's claims to irreparable harm are substantially diminished by its admission that much of the harm would be compensable by damages. Much, not all. Much, not all. Parler's showing of a likelihood of irreparable injury, by the way, they shouldn't have said this. Parler's showing of a likelihood of irreparable injury, particularly in light of its failure to demonstrate a likelihood of success on the merits, is insufficient to support a preliminary injunction. They said it wasn't big and it wasn't enough. Look, we're going to go out of business. Most likely. Absent a miracle, we're going to go out of business. Well, I mean, but there might be a miracle, though. So you're not going to go out. You might not go out of business. That's what just happened. Good job. Serious questions going to the merits and balance of hardships. In the Ninth Circuit, a plaintiff may alternatively be awarded an injunction where it has raised serious questions going to the merits of its claims and the balance of hardships as between the two parties tips sharply in its favor. A preliminary injunction is appropriate when a plaintiff demonstrates that serious questions going to the merits were raised and the balance of hardships tips sharply in the plaintiff's favor. This analysis does not, however, aid Parler's cause. First, as discussed above, the likelihood of Parler prevailing on its claims is not a close call. Don't worry, Parler. You're gonna do fine in this lawsuit. The judge has given you a fair shake. This is just beginning. It's not a close call, the judge says. Parler's allegations at this time are both inaccurate and unsupported, and are disputed by evidence submitted by Amazon. Thus, its motion does not, on this record, raise serious questions going to the merits of its claims. Second, while the balance of hardships may fall heaviest on Parler in the form of potential monetary loss, Amazon has convincingly argued that forcing it to host Parler users' violent content would interfere with Amazon's ability to prevent its services from being used to promote and, as the events of January 6, 2021 is demonstrated, even cause violence. It cannot be said, therefore, that the balance of hardships tips sharply in Parler's favor. They have no chance with this judge. No chance to win this case. Balance of equities in the public interest. This section's infuriating to me. In exercising their sound discretion, courts of equity should pay particular regard for the public consequences in employing the extraordinary remedy of injunction. Parler argues that the public interest favors the consistent enforcement of contractual obligations and lies in fair and robust market competition. But Parler has not at this stage demonstrated a likelihood that it will prevail on its breach of contract, Sherman Act, or tortious interference claims. It therefore necessarily follows that claims do not support a finding that the public interest weighs in favor of granting the injunction. On the other hand, Amazon argues that an injunction forcing it to continue hosting the Parler platform would pose a risk to the public safety. Parler attempts to discount this interest by claiming that at the time Amazon cut off its services, Parler was, quote, already taking steps to develop a more effective content moderation system. There is no debate, however, that forcing Amazon to reinstate its services now, before such system can be implemented, literally what, tomorrow they could be implemented? They could be implemented the day that this happens because they already offered to buy Amazon's AI. Amazon's AI, which necessarily cannot be a violation of its own policies because it exists from the company that sells it. They've already offered to implement it. And how long would this take? A day? 2 days? What do they need? How much time do they need? What do they need? This judge has no idea how fast this stuff happens. There is no debate, however, that forcing Amazon to reinstate its services now before such system can be implemented would result in the continued posting of the kind of abusive, violent content that caused Amazon to shut Parler down in the first place. The judge cannot sustain this claim. This is entirely speculative on the part of the judge. Entirely speculative. The judge has no idea what content will be posted. The judge cannot show with any level of convincing evidence that the same users will post the same content because they've been banned from the services according to Parler. All of the content provided by Amazon to Parler has been moderated off. And the judge cannot credibly or reasonably assert that some other heretofore unknown user will post the exact same infringing or violating content. They can't know it. And they can't know that Parler will not catch it. They have to know that Amazon's contract is literally unenforceable. It's unenforceable. Parler cannot prevent the content from being uploaded 100% of the time. And 98 total tweets or parlays. Remember, that's what was presented to this judge. 98 parlays, specifically, out of 1 million daily downloads, 15 million users. 98 parlays have been presented. This judge has no idea how social media works. I guarantee you. I guarantee you this judge doesn't understand. The court explicitly rejects any suggestion that the balance of equities or the public interest favors obligating Amazon to host the kind of abusive, violent content at issue in this case, particularly in light of the recent riots at the U.S. Capitol. That event was a tragic reminder that inflammatory rhetoric can, more swiftly and easily than many of us would have hoped, turn a lawful protest into a violent insurrection. This is not the language of free speech at all. This is not the language around incitement or anything like that. None of this would pass muster on any claim of unlawful speech. None of it. The court has not in any way tangibly linked the tweets or the parlays that appeared on Parler to the Capitol insurrection. Yet it believes hook, line, and sinker that they're the cause. And it's plain as day here. Court rejects any suggestion that the public interest favors requiring Amazon to host the incendiary speech that the record shows some of Parler's users have engaged in. Those aren't Parler's users anymore. They removed them. At this stage, on the showing made thus far, neither the public interest nor the balance of equities favors granting an injunction in this case. Conclusion, Parler has failed to meet the standard set by the Ninth Circuit and U.S. Supreme Court precedent for issuing a preliminary injunction. To be clear, the court is not dismissing Parler's substantive underlying claims at this time. Parler has fallen far short, however, of demonstrating as it must that it has raised serious questions going to the merits of its claims or that the balance of hardships tipped sharply in its favor. It has also failed to demonstrate that it is likely to prevail on the merits of any of its three claims, that the balance of equities tips in its favor, let alone strongly so, or that the public interest lie in granting the injunction. For these and the remaining reasons articulated above, Parler's motion for an injunction is denied. There you go. There you go. Thank you, Barbara Jacobs Rothstein. Let's see. She is 81 years old, appointed by Jimmy Carter. Okay. Appointed in 1980 by Jimmy Carter. She was appointed to the judgeship before I was born. That's who's ruling on a case involving extremely complex agreements between two internet service companies that provide literally millions of microblogs a day, maybe an hour. 15 million users on Parler and growing. Millions a day. And 98 specific examples. At worst, 26,000 examples. At worst, at absolute worst, 2.6% of what? 2 hours of Parler's services? Less than 0.1% of a day, probably. Wow. Sinak 8 says, by evidence by Amazon, Amazon did nothing wrong. Also evidence by Amazon, Parler will survive this. And the final evidence by Amazon, Twitter doesn't violate the same contract by violating children. This is what people are up against. All right, we're not going to get through, I'm guessing, the, hold on, I got to find the, let's see. What am I looking for? Oh, yeah. This new case against Twitter. Where do I have this? I have this somewhere. Hold on, I'm looking for it. Not that one. Where do I have this? Oh my gosh. This is annoying. Let's see. I think it's in my Discord. We'll take a short look at the Twitter case. We'll get the gist of it from the introduction. Hold on one second. And then we will... let's see. Where is this? Oh my God. I'm sorry. I thought I had this pulled up, but I don't, of course. Of course. I think it's here. Here it is. Okay. Oh, I do have it pulled up. I'm just dumb. Of course. Of course. I had it in a different browser entirely. Not just a different window, but an entirely different browser. My apologies. Okay. Different programs open things in different browsers. All right. See? And I'm only 39. But we've got an 81-year-old judge ruling on extremely more complicated technological issues. All right. Here we go. We're going to read through probably the introduction here. So this is John Doe, a minor child, by and through his next friend, Jane Doe. And this is brought by the National Center on Sexual Exploitation. That's who's and the Haba Law Firm and the Matiasic Law Firm. Okay, here we go. So the counts are benefiting from a sex trafficking venture in violation of the Trafficking Victims Protection Act, violation of a duty to report child sexual abuse material, receipt and distribution of child pornography, California products liability, negligence, gross negligence, negligence per se, negligent infliction of emotional distress, distribution of private sexually explicit materials, intrusion into private affairs, invasion of privacy under the California Constitution. Jury trial demanded. Here's the complaint. We're going to start reading this. I apologize. I don't know if there's any really sensitive information in this. It's 81 pages. We're not going to read all of it. Really just the introduction. Okay? But I want to point out something here. I don't know the quality of this lawsuit. I haven't read it. It might be a bunch of hooey on the actual legal merits of it. But what I will say that I know for a fact is that Twitter actively engages in this behavior. All of it. Actively, happily. They're slow to enforce on it. They're real quick to delete quote-unquote hate speech. They're real quick to delete an anti-transgender slur, but they will leave child pornography up for hours, days, even weeks, because Twitter fully supports child pornography. And they make money from it. This is a civil action for damages under the Federal Trafficking Victims Protection Reauthorization Act, failure to report child sexual abuse material, receipt and distribution of child pornography, and related state law claims arising from defendant's conduct when it knowingly hosted sexual exploitation material, including sex abuse material referred to in some instances as child pornography, and allowed human trafficking and the dissemination of child sex abuse material to continue on its platform, therefore profiting from these harmful and exploitative material and the traffic it draws. Red Guy, 1234431, says Germans consider putting people in camps. Chinese soldiers are putting bombs on their heads. A judge who doesn't use the internet is presiding over a big internet case. New York is prosecuting the Jews. Just a normal 2021 day. Yeah. Yep. That's where we are now. Introduction. Sex trafficking is a form of slavery that illegally exists in this world, both throughout the United States and globally, and traffickers have been able to operate under cover of law online through online platforms. Likewise, those platforms have profited from the posting and dissemination of trafficking and the exploitative images and videos associated with it. The dissemination of child sexual abuse material has become a global scourge since the explosion of the internet, which allows those that seek to trade in this material to equally operate under cover of law through online platforms. This lawsuit seeks to shine a light on how Twitter has enabled and profited from the material on its platform, choosing profits over people, money over the safety of children, and wealth at the expense of human freedom and human dignity. With over 330 million users, Twitter is one of the largest social media companies in the world. It is also one of the most prolific distributors of material depicting the sexual abuse and exploitation of children. Amazon agreed on December 15th, 2020 to host services for Twitter. This was all known long before this. By the way, Amazon Web Services is fully complicit in hosting Twitter's online child pornography. They know that this is a problem. Anyone who has looked at this issue knows that Twitter and Facebook are a problem. Twitter and Facebook have acknowledged publicly that these are problems, and Amazon agreed to enter into a contract with them publicly. Yet they removed Parler for speech that has no connection to the riot. All right. Twitter is not a passive, inactive intermediary in the distribution of this harmful material. Rather, Twitter has adopted an active role in the dissemination and knowing promotion and distribution of this harmful material. Twitter's own policies, practices, business model, and technology architecture encourage and profit from the distribution of sexual exploitation material. Plaintiff John Doe was solicited and recruited for sex trafficking as a minor. After John Doe escaped from the manipulation, child sexual abuse material depicting John Doe was disseminated on Twitter. When Twitter was first alerted to this fact and John Doe's age, Twitter refused to remove the illegal material and instead continued to promote and profit from the sexual abuse of this child. Let's repeat that. When Twitter was first alerted to this fact and John Doe's age, Twitter refused to remove the illegal material. In 1996, Congress passed the Communications Decency Act, which included Section 230. Footnote. Oh, it's just a citation to the act. Congress intended the act to accomplish several things: to promote the free exchange of information and ideas over the internet, to encourage voluntary monitoring for offensive or obscene material. In 2018, in direct response to online platforms knowingly allowing human trafficking to occur and both promoting and profiting from it, Congress passed a bill known as the Fight Online Sex Trafficking Act, FOSTA, and Stop Enabling Sex Traffickers Act, SESTA. As part of the amendment to CDA 230, Congress stated it is the sense of Congress that Section 230 was never intended to provide legal protection to websites that unlawfully promote and facilitate prostitution and websites that facilitate traffickers in advertising the sale of unlawful sex acts with sex trafficking victims. Websites that promote and facilitate prostitution have been reckless in allowing the sale of sex trafficking victims and have done nothing to prevent the trafficking of children and victims of force, fraud, and coercion. And clarification of such section is warranted to ensure that such section does not provide such protection to the websites. And then they have the citation to the publication. Okay. Defendant has benefited financially and or received something of value from participation in one or more sex trafficking ventures by allowing Twitter to become a safe haven and refuge for minor attracted people. Ooh, what do we have for this? Wait a minute. Let me see if I can find this document, because that sounds spicy. Oh, it doesn't actually have maps listed in this. I wonder, they may have changed it though. This isn't the 2019 version. Oh, here it is. Here it is. Just a second. Here's the language they're talking about. So, discussions related to child sexual exploitation are permitted. Oh my gosh, I lost my window. Here we go. Discussions related to child sexual exploitation are permitted, provided they don't normalize, promote, or glorify child sexual exploitation in any way. Conversations about help-seeking behavior of individuals who may struggle with an attraction to minors. advocacy against illegal or harmful activity involving minors, provided there is no sharing of or linking to any material, and depictions of nude minors in a non-sexualized context or setting may be permitted in a limited number of scenarios, e.g. artworks by internationally renowned artists that feature minors, news media reports, media created and shared for scientific or educational purposes. So this must be what they're talking about with becoming a safe haven for maps. Of course, they do not actually enforce this. That's something to remember. But yeah. So let's see, where is that? To become a safe haven and refuge for minor attracted people, human traffickers, and discussion of child sexual exploitation as a phenomenon, to include trade and dissemination of sexual abuse material. Now, this again, though, is their current version. I don't know how to get a copy of the 2019 version. They have it attached somewhere. I don't know if it's in this actual exhibit, or if it's in this actual document. I guess we could check. That's the intro. Let's see if the exhibit's attached to this. Oh, it may be. Here it is. Here it is. Here's their original version that they had in 2019. Discussions related to child sexual exploitation as a phenomenon or attraction towards minors are permitted, provided they don't promote or glorify child sexual exploitation in any way in artistic depictions. So it's been changed a little bit here. They got rid of the as a phenomena language and then tried to add with they don't normalize, promote, or glorify it a little more clearly. They added normalize. That's the only change substantively in that section. So there we go. That's Exhibit A. Exhibit B is Twitter's privacy policy. I don't know what they're citing here. We'll have to look later. Have to end up going through this on a different... oh, this is just their terms of use, I think. Exhibit C. What's Exhibit D here? Sensitive media policy. Civil cover sheet. Okay. Anyway, we'll have to go through this whole document on an upcoming show because this is nasty stuff. And again, Twitter does this every single day, constantly. And despite it being reported, it gets left up. How do I know this? How do I know for a fact that this happens? Because people have tagged me in posts linking to these trafficking sites where they're like, hey, thinking I have some power to do something about it, which I obviously don't. I ask them, please do not tag me in any material regarding the sexual exploitation of children. I don't want any connection to it at all. But people have tagged me hoping that I, as an attorney, can somehow do something about this on Twitter. I cannot. These people maybe can. But when they do tag me on that, those posts stay up for hours and hours and hours, despite hundreds of people complaining about it and reporting these sites. Despite it being spread across Twitter. Please remove this. Remove this. Tagging Twitter support. Tagging Twitter itself. Remove this. This is sex trafficking of minors. And Twitter's like, nah, fam. No big deal. Let's look at one more thing real quick. We can. Related to this story. This has some of the facts in, here we go. Let's take a look at this part. Whoops. This has some of the facts that we'll get to. Again, I'm going to go through this whole document on a different show. It's just getting late now. But here are some of the facts. This is from TechnoFrog. It's a new lawsuit against Twitter. Minor was coerced into making an explicit video, later uploaded to Twitter by adult. Minor proved his age and asked Twitter to take it down. Twitter's reply, we didn't find a violation of our policies. Hat tip to an open secret. So here's from the document. Traffickers also attempted to meet with him in person. Fortunately, an in-person meeting never took place. At some point in 2019, a compilation video of multiple videos sent by John Doe to the traffickers surfaced on Twitter. John Doe submitted a picture of his driver's license to Twitter, proving that he is a minor. He emailed back the same day saying, "Yes, these tweets are videos of me and a friend taken from 3 years ago. These videos were taken from harassment and being threatened. It is now spreading around school and we need them taken down as we are both minors and we have a police report for the situation." And then they have the, oh, Christ. They have the tweets from Fit Males blog and Straight Bros. Whoever's behind those tweets should probably be executed. Just saying. These are spreading around school and is causing many issues. The police and parents are both aware of it. Videos were taken 3 years ago, but are now being resurfaced. It started about a week ago going around school. Me, Redacted, and also Redacted are in these videos. On January 28th, 2020, Twitter sent John Doe an email that read as follows. "Hello, thanks for reaching out. We've reviewed the content and didn't find a violation of our policies, so no action will be taken at this time. If you believe there's a potential copyright infringement, please start a new report. If the content is hosted on a third-party website, you'll need to contact that website support team to report it. Your safety is the most important thing, and if you believe you are in danger, we encourage you to contact your local authorities. Taking screenshots of the tweets is often a good idea, and we have more information available for law enforcement about our policies. Thanks, Twitter. Keep your child porn up, Twitter. Good job." This is the company that Amazon's doing business with, by the way, but not Parler. But I will be covering this case in much more detail. We'll go through the entire complaint coming up very soon. Not tomorrow because I will have Nate the lawyer on, probably either over the weekend if I do a special weekend show or on Monday, depending on guest scheduling. So if you want to follow the fact that Twitter promotes actively child pornography on its services, and Twitter does because they love it, because they make money from pedophiles. And Twitter loves pedophiles. If you want to follow that case, make sure you tune into that show. Get Razor on? I would love to. I would love to. Okay, that's the bulk of the show for tonight. We're going to go ahead and read through the remaining chats. Thank you all so much for coming. I appreciate it. I'm sorry I was tired at the beginning of the show. Had a long day, but hopefully you found the show educational and entertaining at times and only mildly infuriating for most of it. But these live streams are truly a pleasure for me to be able to do, and I enjoy them greatly. So that being said, let's read through these. After this, I will go on twitch.tv/Ricada Law, and you can join us for a movie on Amazon. I'm not sure exactly which movie yet, but there's some quality selections. So that will be immediately following the show. All right, getting into the chats. We've got Mario Carter 13 says, if he's going full Epstein, let me be the first to say Jack Dorsey didn't kill himself. He only killed Twitter. It'd be nice if he did kill Twitter. Adrian Valladares says, hey, Nick, here's an idea to get through your future 24-hour stream. Step 1, get Drex, Dollhouse, Phil, and Ty on at the same time. Step 3, let them talk and go to sleep. Step 4, wake up and see them still rambling with chat, somehow still flowing. Step 5, profit. Mario Carter 13 says, Obama, you voted for hope and change. Biden, fuck, go back. Crusader Saracen says, does anyone honest to God believe this guy got the most votes in the history of America? If you do, I got a bridge to sell you. Referring to Joe Biden, not to me. Joe Biden says, did I release the kids from the cages today? No, not until I sniff them first. Come on. Crusader Saracen says, what a beautiful moment. My 2-year-old just saw Joe Biden on the TV and said, Daddy, that's the man who levitates at the foot of my bed every night. Then he said, fuck off, Dad. Don't make up fictitious quotes I didn't say to score cheap internet points. Oh, nice. Mario Carter 13 says, if you need an abortion, consider going to a courtroom. They specialize in miscarriage of justice. Solid dad joke. I like it. Malik Foxton says, apparently the judge doesn't know what Google is. No. Silky John, the judge doesn't know what their own filings say, apparently. Silky Johnson says, hey, Nick, I read an article about how the Kentucky GOP censured Turtleneck Mitch. What does that mean when a state censures one of its senators? I'm also glad that Twitter takes the time to regulate dangerous legal speech, but CP is totes okay, fam. Shit. Censure from any legislative body is a toothless act, but it's a statement of formal condemnation. That's all. It just says, what you did was bullshit and we don't like you. So it doesn't have any real effect on him other than letting him know that they disapprove, and more importantly, letting their voters know that they disapprove of him as well. Crusader Saracen says, not to tempt fate or anything, but as a thought experiment / legal exercise, if Jack as an individual or Twitter as an entity sued you for defamation, what would be your strategy and legal defense? Keep doing the Lord's work and rev up that wood chipper. Oh, that is true. That would be that one, that it's true. Two, that they were trying to silence my speech, depending on where they sued me. But most importantly, that it's absolutely true. It's obviously true. It's alleged in this lawsuit credibly. I've seen it happen. It's demonstrated. It's a known issue that they support, distribute, disseminate, and profit from child pornography. And despite having AI that can detect the intent behind jokes, they allegedly don't have AI that can detect nudity and pre-screen that in some sort of way. It's more important, apparently, for the interest of free discussion to have nudes go up and explicit hardcore sexual material go up on Twitter. It's more important for that speech to have immediate access rather than a review process and not have an algorithmic AI take care of that for them than it is for them to protect children. There is software that you can install on an iPad called like Christian Eyes or Covenant Eyes. Covenant Eyes software will determine nudity on an iPad screen. Not nudity from the source material, nothing else. From an algorithmic review of the image that is displaying, and it will block it. And you're telling me that a small Christian startup company can block nudity from displaying on a screen, but Twitter doesn't have an algorithmic way to look into child porn? And then when they're presented with it, they just say, nope, didn't violate our policies? Come on. Stop it. These people can do literally everything. Literally everything. And hey, it's Twitter, right? There is no free speech concern on Twitter. Let's be very clear about that. They've stated over and over and over that there is no First Amendment protections on Twitter, and there is no concern for free speech on Twitter. Therefore, violent, hateful, abusive, whatever type of words can be, according to Twitter and all of its sycophantic, ball-sucking supporters, all of them will say that Twitter has every right to police its content in every way. So they can't come out and say, well, you're anti-free speech if you don't allow child pornography to be up on Twitter. Fuck them. These people are the most dishonest people in the world. Twitter regulates constantly, but not this. Why? Why? Because Twitter profits from the exploitation of children and adult women who are trafficked. And they do it happily. They make tons of money on it. That's why. They're an awful, awful company. Let's see. So yeah, I would just argue truth all day. All day. Ed Gein's no. Corporate media whore says, hey, I just want to let you know that the claims made against Twitter are totally false, and here are my articles to prove it. How Trump fostered child exploitation with his bigoted, racist, and COVID denial tweets. There you go. Fantastic. Ed Gein's Pocket Pussy says, I just want you to know that if you had done a Tombstone watch party, that none of this bullshit this year would have happened, probably. You're right. I'm really upset with myself, Ed Gein. I am. I'm honestly mad that I didn't do it. Crusader says, if the judge presiding this Twitter case is an old fogey, would it be worth it for you to submit a legal addendum the same way you did in the Vic case? Clarify what you just ranted on. Leave no stone unturned, as it were. No, it wouldn't be. I'll leave it to the professionals. They'll do a better job than me. I mean, I'm a professional, but I'm not licensed in California, and these people do literally this type of work, specifically. Borer135 says, did you see the unlisted White House video from today? I have the link and timestamp. Yep, we watched that. Thank you. Ransu says, weekend in Bernie's. More like weekend at Biden's, am I right? Razgriz says, Arch Warhammer just uploaded. Looks like he got his channel back, which is great. Patrick Eno says, dude, go to 1:16:38 in the White House video. Hunter legit glitched in saying he took a plea deal. Would love to see your reaction. Well, you got it. We did it. Red Guy 123443321. Even prisoners can be better pro se litigants than her. At least they can use a library. D Grubs MD667. Welcome to lawyer status. Thank you for joining the channel. It's much appreciated. Kidda says the U.S. military has entered Syria. It didn't take them 24 hours to put us back at war. D Grubs MD667 sent a donation. Thank you. Stabby McStabswood says truth. Versi, I might have missed yours. If Versi says, really sorry, Nick. I had an important work phone call. I didn't see your post. Oh, no problem, buddy. Welcome. Glad you made it. Sorry if I missed this super chat. I don't remember if I read it or not. I remember seeing it. Can't remember if I read it. But now I have. CJ says, well, we know you don't need blue pills, coach. Ben Frail says, Google threatening to withdraw search for Australians over the news shakedown order last year. Google and Facebook ordered to pay when people share news stories. Red Guy says, if that is the judge's opinion, then Parler is boned. Yeah, I don't think Parler has much of a chance at all. Vine the Cold One says, me thinks Parler is living in another world. Red Guy says, can I sue this judge for writing defamatory content? No. Bad Vibe says, is Parler playing softball for potential mediation? I hope that's not their strategy. They needed this injunction. That's what they needed. Birdie Merck says, thank you for this show. Very informative. Cheers. Thank you. Red Guy says, this judge is going to be the next one nominated to the Supreme Court. Ransu says, Twitter hosts CP, but Pornhub gets the ban hammer. Yep. Yeah. Facebook and Twitter are the biggest distributors of child pornography online. By a mile. By an absolute mile. Facebook has, in fact, faced lawsuits from its own reviewers for just how much child pornography, child mutilation, and child killing they have to watch in their moderation efforts. Facebook is a haven for it. So is Twitter. John Crook says, can anyone get me a source on new Syria deployments, or is this just acknowledgement of previously suppressed deployment numbers? No, I think I saw a report about it where there was a military convoy that has entered Syria after Syria's demand for the withdrawal of troops. Radioactive Rico Gaming says, do you think having a button to report CP next to the picture could be abused by people trying to suppress others' content? Sure. Of course it could. But again, Twitter is all about suppression of other people's content in the name of public safety, just not in the name of the safety of children. Twitter is much more concerned that you saying a string of words will somehow spark a riot 1,000 miles away from where you are than an actual child being exploited on their platform. Because they make money on the kid. Jack Posobiec has the story on Twitter for Syria. Thanks, Kidda. All right, guys. There is the show. We're right after 2 a.m., so timed out pretty well. Considering I was late, we'll end this show almost exactly at 3 hours. We do have the outro to play in just a moment. I know it didn't play last night because I had a guest. Meximan and Cheese says, I think Twitter is allowing CP because they want the outrage. They want the government to come in with burdensome legislation they can handle, but will stop any new potential competitors to the current establishment players in social media. That could be. That's what they're alleging with the 230 stuff. However, they're not allowing the outrage speech. So, all right, guys, there you go. Thank you so much for hanging out. Synac 8, what did I do? Thank you so much for hanging out. I will hopefully see you over on Twitter. I hope you have a wonderful night, and we will talk soon. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along with his glass.
I meant on Twitch. Oh my God, I meant Twitch, not Twitter, not that haven of pedophiles. Ah!
With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folk from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Planning tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed